2024, the Honorable Supreme Court itself clarified that
It's all right, but what do you want now?
we want that both the executing court as well as the district judge are refusing to follow the 2024 Supreme Court, my lords.
It's all right. What is the pressing urgency?
Urgency is the attachment, my lords. Now they are going to attach the...
When the matter?
Tomorrow is there for the executing court, my lords. I urgently pray it be taken up at 2 p.m. my lords. Yesterday we have filed it. I'll supply the number within half an hour. Your lordship may kindly...
Let it be tomorrow. Let it be tomorrow, the first item.
First item tomorrow.
Let it be tomorrow.
I'll be supplying the number within
tomorrow. The execution court is taking up the matter tomorrow.
Yes,
for attachment.
Yes.
I may be pardoned to mention your lordship.
Number 10.
Bail matter you can wait for 2 days. How many days? I don't know, my lord.
Application for release of the petitioner because his marriage is there on the 18th.
18th. Have you supplied the copy to the other side?
Yes.
For verification?
Also annexed the marriage card.
You might have given it to the prosecutor which attached to that court. Unless you give it, how will they verify?
I saw it
Today you serve, we will
today
see.
itself I saw.
18th is marriage.
I may be pardoned to mention your lordship.
Day after tomorrow, huh? Day after tomorrow, because tomorrow will be very tough day. They'll verify also. Today you supply the copy, they'll verify it. Take it and verify because 18th is the marriage. I'll take it up on 11th.
Malaship, allow me to mention a matter. This is a very urgent because the mother of the petitioner is on deathbed, Malaship. He's in ICU, Malaship. Petitioner is in the custody for more than 10 years, Malaship. So his bail matter need to be because we have already filed for interim bail, Malaship, if he can be released.
Interim bail on the ground of health ground of your mother.
The mother.
Okay. The copy of the
already we have served the copy.
Give it to them also now.
We will provide them.
Provide it 11.
Malaship, because if it can be done maybe tomorrow, Malaship, or if it is the end of the board.
They need at least 1 day to verify. Give it. They are
okay. So Malaship, if it is because I am traveling from Delhi, if it can be done on tomorrow.
All right, day after tomorrow, because they have to. They need one at least 1 day to verify.
Okay.
You might have given to the prosecutor who is appearing there, isn't it?
Okay, I'm providing.
Yes.
Regular bail, your lordship, in respect.
Regular bail will be taken up that.
Vigilance, my lord, in
regular bail will be taken up that.
Very
pressing urgency.
Only for DA he is in custody from January.
What is the pressing urgency?
The urgency is that by today we are supposed to deposit 20% of the check. And
138 matter. Heaven is not going to fall. 20%. What will happen?
Today is the last day.
Then what will happen? NVW will be issued. I'll quash it. Don't worry. I'll quash it. Come on Monday.
I may be pardoned to mention your lordship.
20% Monday. No. 138 matter, 20%, that is statutory requirement. You have to deposit as simple as that. I understand it, but what is wrong in that order?
The only thing that honorable advocate would have held that.
Oh, it's not directory, it is mandatory. Yes. Oh, that judgment you also, I know.
I may be pardoned to mention your
lordship. What big difference?
Where only Friday?
No, it's Monday.
I may be pardoned to mention your lordship. Your lordship, item number 96, weekly list.
Wait. Please, by will call. Any out of list mention?
My lord, this is the against the discharge order. And
give the memo.
My lord, CRR revision petition, I for hearing. Last occasion it was listed, but due to opposite party to
give the memo.
It's a criminal revision matter. Site number 3.
Please give the memos. Don't tell me. Okay. Give the memos.
My lord, item number 54.
1 minute. Now, page.
May I be pardoned to make a mention out of the list mention, Your Lordship?
Yes.
Your Lordship, one criminal revision 439 of 2022. It has been filed by the CBI, Your Lordship. They have challenged the impugned order discharging the opposite parties of offences under the PC Act, Your Lordship. The trial has been...
Against discharge order.
Against discharge, the CBI has come.
Somebody discharge, what is that?
The trial is progressing, Your Lordship. The matter will become infructuous, Your Lordship.
All right, I'll take it up. Give the number.
Yes, Your Lordship. Yes.
Any out of list mentioning? Online, nothing. Yes.
Pardon to make a mention, my lord. ୱିକ୍ ଲିଷ୍ଟ ଆଇଟମ 102 ଅପିଲ ମାଇଲର ସିଆରଏଲ ମାନେ 18 ମସିହାର କେସ୍ ମାଇଲର ଭିଜିଲାନ୍ସ କେସ୍ ପ୍ରୋସେସ ଅଲରେଡି କମ୍ପ୍ଲିଟେଡ୍ ମାଇଲର I have filed written note and citation everything to the government also. Kindly be fixed
You-
date for supplementary.
You be ready by 3:30. If I get time, I'll pick it up. Okay?
My lord, item number
1 minute. Anything on
Monday is a holiday, my lord.
Tuesday?
Tuesday.
Yes. Next.
You mentioned item number 1 to 7,
Yes.
8 to 22.
Your lordship, item 21.
What do you want?
The vigilance person will be absent, your lordship. He informed us, so we may be accommodated on Tuesday, your lordship.
Arjana? Yes.
Item 16 may be taken up after 2 weeks.
16?
Yes, ma'am.
Yes. On the request of Legal Counsel. Yes.
Item 23 to 34.
Item 15 may. Item 15, next week, my lord.
15 on the request of.
35 to 43. 44 to 51.
May I please, your lordship? May I beg
What
to
is it?
pardon, your lordship?
I am the opposite party in that case.
57?
47.
47, yes. What do you want?
And the opposite party that it is not extension time for removal defects. The petitioners file a IA.
What do you want? Are you asking for an adjournment?
Adjournment perhaps.
Let them come. You are not sure what you want.
I am the opposite party in that.
Let us see then. Let the petitioner come. Yes.
May I please, your lordship? My lord, I am in the BC, your lordship.
Yes.
My lord, item 50 on behalf of Mr. A.R. Ponda, my lord, matter may be listed for tomorrow, your lordship.
Not tomorrow.
My lord, he is ill, that's why.
As per your convenience. If you want an adjournment, tell me. I will adjust accordingly.
Oblige, your lordship.
Yes. 46 will be. Yes. Yes.
52 to 57.
Okay. 52 on the request.
My lord, 54, I'm appearing on behalf of Pikanda. He is an application matter. 54. After 14th of April.
You are appearing for whom?
OP1. Advocate PK number.
51.
54.
Mr. Rajit Roy was there here for petitioner. Have you told? Yes. 54.
Yes, my lord.
He's asking for adjournment.
Lordship, kindly adjourn the matter, my lord.
Adjournment? Okay.
Obliged.
Yes. Yes.
58 to 67.
65. Next week, any date. Yes. You will sort this out. Sort it out. Yes.
Obliged. I am appearing for the opposite party. 61.
Yes.
68 to 75.
Madam, 69, my lord.
Yes.
Madam, I am appearing for the opposite party. Senior advocate SK Patnaik is out of station, madam. Some other day, my lord.
Who is our petitioner?
No problem. My lord, item 74. I am for the opposite party. I am praying for 1 week time to
Who is our petitioner?
Senior advocate Mr. Sharma is appearing for the petition.
Have you told
I
him?
have intimate his associate. Interim order to continue. There is an interim order.
Next.
76 to 81. 82.
Pardon, my lord. Weekly list of old building, court number 3, my lord. Item number 323, CMP number 310 of 25. In this case, my lord, the trial court has rejected.
Weekly list I can't take up. Weekly list of some other court I will not take up. Urgent matters only.
Urgency is there, my lord.
What is the pressing urgency? We can't wait for 2 days.
Trial court has rejected the application for accepting the WS, my lord.
Oh,
Suit is fixed to 15th for
all right. No problem. Nothing left. Yes, next.
One.
Made fees lordships.
Yes.
My lord, in this case, my lords, the scheduled offence has been quashed on 13th of February 2025. And your lordship knows that Lord Vijay Madan Lal, they have said that if the scheduled offence goes.
Is it so?
The lordship.
Yes, subsequently, this court, by the judgment dated 13/2/2025, allowed the CRLMC number 2091 of 2022 of quashing the reliance. On that basis, the petitioner has moved IA number 808 of 2025, making it a substantive ground for quashing of the entire property in the PML. Since in view of the subsequent development, Mr. Parijan and counsel for the senior counsel appearing for the petition seeks to withdraw petition to the liberty to file a press petition.
Yes, ma'am.
Press petition. Liberty is that the petition is disposed of with the liberty to file a press petition.
One line,
Yes.
I will move an application in the trial.
I'm not entertaining this petition. How can I pass it?
I'll leave it at
Don't pass it. You file it, mention it, I'll take it up. What is the case? And supply the copy.
Yes, sir, we'll do that. Great, sir.
Yes.
May I please also? Hello, I'm for the OP. Due to some illness, the informant was unable to present before the summons.
What do you want?
Arjun.
Urgent. On the request of for the petitioner. Yes.
Item 3.
Issued in the execution proceeding. I have made a submission last year, Lord.
Mike.
I have made a submission that maintenance order, basing on which the execution was filed, has already been set aside. And your lordship,
Yes, madam.
May I please, your lordship? I have got the order last night, so I have to go through the order. And I pray for 15 days time. If necessary, I may file a revision. on
it
it.
cannot be allowed. I'm supplying.
She says that she is not.
I
will file revision.
it has
Only 15 days time. Because of maintenance was set aside, so mother and son will suffer. So
pending
But these
execution
are-
proceeding is not there. I am not, your lordship may grant me time, I am not on that.
maintenance order was
Unless-
there.
What I think, my lord, presumption is that the matter was remanded.
Yes,
And 1 month time has been granted to the court below to dispose of the things. So even if fresh maintenance is awarded, they have to file another fresh execution. So this execution has no meaning. Kind of unnecessary application.
only I pray for 15 days time. They have prayed many times.
No,
But I am
you are-
only praying for.
But he is correct there in the sense unnecessary is pending. You also are not going to get any benefit.
Only-
What I do is,
Only I have.
what I do is, madam, what I'll do is I'll put it on 17th of this month.
Yes.
You please reconstruct.
Yes.
17th, let it be.
Also, no,
Inner
I don't know.
personal grounds he's asking basically.
Yes.
17th, madam.
Yes.
And rather you have to resort to some other remedy. As
Yes.
from too much.
I would have case me reached here.
ठीक है 17. Yes.
May I, with the lordship's kind permission, I'm sorry, Lord. Item number 1 minutes, may I pay return of annexure 1 and 2, certified copy return.
Certificate copy return.
Return of
Certificate
annexure
copy
1 and 2.
replacing the photocopy.
Deep blue flash.
Rather you write Mr. Agrawal pointed out that the subsequent ground on the basis of which the subsequent ground the ground on the basis of which the petitioner now seeking quashing being a subsequent ground cannot be entertained in an IA. IA moved in the main petition. Yes.
Item 4.
In this case, my lord, may I please, your lordship? In this case, my lord, a proceeding was initiated, criminal proceeding was initiated on the basis of the final report of the state level scrutiny committee. And that was also challenged before the writ petition. In the writ petition, the said order was passed. Now remanded back to the committee again for de novo inquiry. The criminal proceeding now pending, your lordship. I paid for quashing of the same in view of the quashing of the inquiry.
It will depend upon the outcome of the decision.
The subsequent when it will finding
It's only remanded. Where is that order? Show me.
Yes.
it quashed and remanded, not remanded. Quashed and remanded.
Show me.
Yes. Important has been quashed.
Show me that order.
Yes.
Have you not made the part of the record?
No, I have already earlier given, my lord. Earlier given copy, your lordship, as well as the
Copy
petition.
given, unless you file it, it won't go.
Yes, sir. I have also filed, my lord. Earlier occasion.
It's there, already there.
Yes, my lord, I had given it.
Already.
Your lordship, paragraph 4, your lordship say.
4.
In view of the submission made by the learned counsel for the appealing for the party, while quashing the impugned order dated 17/12/13, so passed in FCC case number 18/12, 90/12, and 91/12. The present case is disposed of in the light of the order, so passed of the 25864 or 2000 petition is directed to appear before the state level scrutiny committee along with the copy of this order.
What is happening there?
Yes.
What is happening there now?
Well, the committee is going on inquiry, but now once
Suppose the committee will find something.
again press inquiry, your lordship, press prosecution will be
It is a cognizable offense.
My lord, on the your lordship, see, the committee report is the FIR.
I understand it, but see, when a cognizable offense is made out, anybody can be a complaint.
My lord.
And the committee has given a report on that basis. The cases has been
No. My lord,
and which has been quashed by the High Court.
Yes, my lord.
Not exactly complete quashing. It is rather remanded back for
No, your lordship,
I don't know what will happen there.
No, your lordship, no, the committee report has been challenged in the writ petition. On the same report is the FIR.
I understand it,
Yes,
sir.
madam.
This much I could understand,
Madam.
but at the same time, it is not only quashed, it is remanded back.
Yes, my lord.
Remanded back.
That is such
What is happening there?
held that
my lord,
What is happening there?
what
You have any idea?
is going on?
have to ascertain.
I said it.
My lord, my question, your lordship submission is that de novo inquiry, once the committee report is quashed, and on that basis the criminal proceeding has been initiated. How can
Where is on the merit it is dealt upon? No case is made out against you?
my lord, so for the
It is one word remanded back and
your lordship, all cases, your lordship know how the inquiry whether it will come against.
That's right. Where is it?
How can it can be predicted? The criminal proceeding go on, my lord. Suppose I am convicted, my lord. Suppose I am convicted. The criminal once the report has been passed, on which basis the proceeding has been initiated, how can you maintainable at all?
Sir, show me the substantive writ petition which was earlier disposed of for giving a detailed order.
Yes, sir.
What is that?
The cover matter I can give.
Give that at least, because this order is neither here nor there.
Your cover matter.
One word.
Your lordship, next week, your lordship. Next week.
I'm
I'll
bringing the
give that.
chapters. Which chapter?
Your similar cases, your lordship. Yes,
The date to obtain instructions regarding the press, regarding the status report, the press inquiry being conducted by the
state level scrutiny.
State level scrutiny.
Yes.
After remand. Yes.
Well, so let me take it next week. Your lordship.
Yes, next.
Item 5.
He'll give a date. He'll give a date. Yeah. 5. Password.
Item 6.
May I please, my lord? My lord,
Item 6, my lord, pass over.
item 6 is mine.
5 or 6?
I'm sorry.
Pass over. 6.
6. Yes.
Item 7.
May I please, your lord?
Item 6 is mine, my lord. Item 6 is mine.
Yes, ma'am.
Calling which one?
Biswajit Bhuyan. CRNMC. Supplemented list, my lord.
No. Papa, 8.
One second, I'm sorry. No.
If you handle more case, that's the problem. You now time has come that you lessen your burden. Yes.
May I please, your lord? Here, my lord.
6.
Item 7. 6 passed over somebody was.
7.
Yes. My lord, here I am the victim at the hand of the officers of the ED under PML Act. They have exercised their power under section 71A without following the rigor of law. My lord, the person from whom all these things are seized, these are all proceeds of a loan accounts. When my vehicle was purchased by virtue of taking a loan, and the money which they have seized, these are all loan amounts. And all in a sudden, my lord, they came and searched the house of a person, namely Chandrasekhar Samal, who is no way related to my company.
Yes.
My company is completely a different and distinct company. And he was never in my, he's on the date of, my lord, alleged seizure and freezing of my account, he was nowhere related to my company. But the vehicle was seized because it was parked in front of his house. It was seized and all the bank accounts of mine have been freezed. I would like to draw your lordship's attention how, without anything in the order that what is the reason of such seizure, how these proceeds of crime came to my hand. Absolutely nothing is silent, which is sine qua non to constitute an offence under Section 3 of the Act. TML Act says, my lord, there must be a proceed of crime.
Yes, let us see.
Yes, ma'am.
Yes.
My ground of the impugned order is at Annex 3 page 34. Kindly have a glance.
Yes.
This ECIR was instituted way back in 2020 against some other person, my lord, other company. And these two in the table, if your lordship find, these are residential address of Chandrasekhar Samal located in plot number so-and-so sector CDA Cuttack. This amount they have seized from my account, my lord, CC account in the bank, ICICI Bank opposite party. I have also.
This matter was heard.
Yes, your lordship asked my land friend to.
Yes. I think this Chandrasekhar Samal will take the relation, something of that sort.
I have got the instruction, your lordship.
I am for the OP4 ICICI Bank.
What is your name? What is your name? Your name is Sri Monopoly. Huh? You are Sri Monopoly.
Monolithic.
Monolithic.
It's a company, my lord. The company represented through managing director. Your lordship, kindly say paragraph 2.
Para 2.
Para 2, my lord.
Have you given the copy to me?
No, yes. My instruction, my lord. It's only.
It's all right.
Let all right.
Yes, further during the recording of statement of immunity.
He himself stated, my lord, that he is one of the directors.
You have to verify. He may.
That's correct, my lord. But he stated, if your lordship say, I'll file affidavit, my lord. No, my lord. Your lordship kindly see. Last time also
Prime Minister of the country also.
Your lordship also turned the next page, my lord.
Yes.
Sri Chandrasekhar Samal, director of Messrs. Sri Monolithic, submitted bank account statement of the above company before this directorate.
May you file everything. This is something, you know.
That's why I said I have got the instruction because my officers are saying.
Let him file this.
Let him, because my valuable car is exposed to sun and rain, my lord.
Therefore, I am saying.
Only I'll not hand over any restriction your lordship may impose.
But
what is the condition of the car last 3 months?
Try to understand, these are payment unless something
So
comes on.
let the freezing account may be considered to your lordship in the final order.
File the affidavit and put it next week. Unless this comes on record, I can't do anything.
I am for the OP4 Millard Bank ICICI Bank.
OP4.
Millard.
Who are you?
Bank.
I'm the ICICI Bank.
Which bank is it, my lord? My account is running there.
He has taken loan from you.
No. I've taken a different bank. It is.
But the account maintained.
CC account.
Account maintained in my bank.
Ultimately, they have to implement the order, your lordship. If your lordship defreeze the amount.
The account is maintained with us.
Now, my lord, we have already filed OA before the adjudicating authority. So he is to move before the
These are all empty formalities.
I'll tell you. If you wrongly implicated him, I will have to quash.
That's correct. That's correct.
Why should he suffer? Let us examine if it is not wrongly, then some link is there, then he has to face it.
Yes.
If there is no link at all.
My instruction are, my lord, he has the link.
Let us see what link you have. But this link which you are showing in para 2 is not the link. You also know that. So therefore I want an affidavit.
I am helpless, my lord. Whatever they have said, that's why
let the affidavit come.
Let him supply prior to.
Affidavit.
Your lordship fix it to next week.
Yes.
Next 15.
Not 15. Let it be on
16.
21st.
Next week, your lordship, you are saying, because
21st, the holiday. In that 3
3
days,
days, any day convenient to my lord.
3 days would be very, very tough.
17 I time, my lord.
Okay, 17. Okay, 17. 17. Shall I write? We will file the affidavit. I'll pass the hands of the written instruction and emphasize on para 2 of this. Para 2, 3, and 4. Let the affidavit, let this instruction be filed short by way of an affidavit. By way of affidavit, leave the matter on 70.
Item 8.
Item 8, my learned esteemed brother, Mr. Maharana, is appearing for the vigilance, your lordship, praying for passover, lordship, after lunch.
May I play for tomorrow, my lord?
Tomorrow may not be possible.
Otherwise, next week, my lord.
Next week, in the both 100 hours. Let it be on 21st, 21st, 22nd,
22nd.
22nd. 22nd.
Item 9.
Please, your lordship. Lordship, I am on issue, my lord.
9 also praying for passover, lordship, after lunch, Mr.
Yes,
Maharana.
Passover, Mr. Maharana is seeking Passover. Okay? Passover.
Item 10.
My lord. My lord, this is offense under section, my lord, 498A, my lord. My lord, chances to reunion, my lord.
Your for husband, as usual.
Hello, innocent husband, my lord.
This is arising out of a matrimonial discord. So the petitioner is seeking quashing of petitioner being the husband.
My lord.
Husband of opposite party number 2, seeking quashing of the entire quashing of the Gunupur case number 16 of 2023, registered at the opposite party number 2 against him. The counsel for the petitioner submits that this being a matrimonial dispute, there is a scope of out of court settlement. Regarding head to the statement made by him, I'll refer it to district mediation center.
No, my lord, Amar mediation
No,
center.
she is staying where?
She is staying, my lord. My lord, Gunpur.
No, you have given the address of
Husband Ganjam, my lord.
Seragoda, Ganjam.
Husband staying at Ganjam, my lord.
And I am talking about the wife.
Wife, my lord, in Gunpur, Rayagada.
Let it be in Gunupur.
The problem is what happened, my lord. ମାନେ ସେଠି ବାହାରୁ ଗଲା ବେଳକୁ ସେ ଆକ୍ଚୁଆଲି ସତ କଥା ହେଲା ସେ ଓକିଲ ମାନେ ଯୋଉ ବସିକି ସେ ଯୋଉ କରୁଛନ୍ତି
Then you have to bear the
ମାନେ ଏଇ କ୍ଲାସରେ ଆମେ we are ready.
Will you bear the expenses?
Yes, sir. ଆମେ ଦବୁ ଏଠି ଆସିଲେ
Must bear the expenses.
my lord, my lord.
It's a High Court Mediation Center. Immediate a particular date. Party. The petitioner, how much you will deposit?
My lord, 1,000. 1,000.
What 1,000?
My lord, Rayagada.
Come from Gunupur.
My lord, Rayagada. My lord, train master Gunishwar is sanction. My lord, 2,000. My lord, husband manakar avastha kharab, my lord.
What are you doing?
My lord, engineer, my lord. My lord, engineer में कौन फीस है? Man, गोटे डेटे खाते हैं बहुत. My lord, तुमने बताना हो, my lord.
Paying to your wife only.
My lord, तुमने बताना हो, my lord. तुमने बताना.
She will come from Gunupur.
My lord, my lord, professional train में ऐसे, my lord, 250 ना पड़े. Oh, my lord.
You are so reluctant to pay to your wife also.
My lord, my lord.
Yes.
Oh, my lord.
May I please, your lordship? My lord, the petitioner challenges the order dated 4/11/24 by the annex of 3 as page 17, my lord.
17.
17.
17?
17.
Yes.
Where the 457 application was rejected by the law and court bill on the ground that confiscation proceeding is pending. The fact is that, my lord, that the
Against this order, revision line.
482.
No.
My lord, some of the judgment. My lord, our own High Court judgment is also in 482.
Why the revision before this court? Why have you come? Anyway, forget about it. On merit, if you have a case, it's all right.
My lord.
Yes.
And the fact is that, my lord, the petitioner husband, the vehicle is in the name of the petitioner. His husband is carrying.
Confession proceeding is now going on. So I have to ascertain what is the stage of it.
Well, stage I have taken instruction yesterday that it is pending.
Yes. Next.
Item 12.
My lord, on 22.
You give a date. Maybe you notice, let him get the instruction. Mr. Knight to obtain instruction regarding the matter of the confiscation. Yes, sir.
Item 12.
May I please, your lordship,
let's quashing a prosecution arising out of a complaint case registered under 156(3) for 20 milord. The rift between the petitioner and the opposite party number 3, the father of the informant of number 2, is for a long 6 years. There was some transaction for giving admission. So
Admission where?
Admission in college of the opposite party number 2. So my humble submission, it may notice may go. So there is some harmonious restoration of relation because they are the friend.
What are you were working there?
Prosecution is progressing, my lord.
No, you were employed there in his college or what?
No, I'm the taking mediating for admission of the OP number 2.
It has become a profession.
My profession, I'm the
persuading student to come and join.
No, I'm the family friend of the.
That's your job.
I'm family friend of the. That is the allegation.
But whatever he is doing,
I'm not. I'm given the impression that I will give her admission in college.
This is a big scam nowadays.
But it took in the year 2014, my lord, and it took long 6 years while complaint, my lord. So there is some rift.
I have simply issue notice. But the conduct is a very. This is a big scam.
My demeanor is.
I'll just issue notice if you can settle.
If they come, then maybe.
It is a 420 and all.
Yes, only
between you. If you.
Police are boss aside other allegations. Only 420.
One thing is that out of 17 trusted witnesses, lordship, 7 witnesses already been examined. So far, my.
That I've said.
I simply issue notice.
Only notice. Only notice.
If anything
it can be nipped in the bud, then we will find.
Yes.
Oblige me, Lord.
30.
Short date so that. Oblige me, Lord.
Husband and wife, both are doctors. The domestic violence proceeding instituted by the wife, the parents-in-law are before your lordship seeking quashing of the proceeding. Your lordship may straight.
You are the
parents-in-law.
Parents of the husband.
Yes. Your lordship may straightway take annexure 1, which is the notice from the DD Act case, and take page 32.
32. Yes.
Column number 4.
Yes.
Between 2011-17 and September 2019, application presented in 25, and that too after the husband gave a notice for amicable separation by mutual consent. There was no response. He instituted a proceeding for divorce. Divorce proceeding notices were served. The father of the girl came and said that unless and until you withdraw the case, I will institute multiple proceedings against you. And on 19th, a station diary entry was made at the instance of the present petitioners in the Chandrasekharpur police station, saying that this is what has happened.
There is no 498A so far. You're lucky that. This package, what to do? Yes. I'll issue notice. Not for anything else. See, they are parents.
State is not
age, just see the age, 65 and 74. And incident from 2017 to 2019. Case is filed in 2025. Is it not enough?
State is permitted, my lord and senior not permitted. State is a party, lordship.
State is, no, you can't be. Deviate. I simply issue notice. Yes, issue notice, and you move application for adjournment.
Pray for stay of the proceeding because they have proceeding every day. They will have to, otherwise they will be hounded.
No, but in that complaint, let us see the complaint. The husband is also a party.
Kindly see the complaint, how mechanically it has been done.
And husband is a party to that.
Husband is also a party. Husband lives in Australia. He is not even here.
Oh, then that's right. I hear it. Mr. Mukherjee, they are accounting for the petitioner. The means that the petitioner number 1 is the mother-in-law.
Mother-in-law and the father-in-law.
Petitioner number 1 is the mother-in-law, and the petitioner number 2 is the father-in-law of opposite party number 1. He has taken me to the complaint. Complaint. Para number complaint, na? Affidavit.
Yes.
That is the affidavit.
Affidavit filed by-
Accompanying the DV Act.
Affidavit filed by the opposite party along with the proceeding initiated by her and under section 12 of DV Act. In a para 4 reads as under 32 para 4. The deponent had been living with the respondents at Bhubaneswar since 2011-17 to September 29. Inverted comma close. Okay. And the complaint is filed on
20th of February.
of February 2025 after lapse of
6 years.
6 years. Issue notice to opposite parties, and in the meantime proceeding in
DV Act, DV Miss Case number 22 of 2025.
2025 qua the present petitioners state. Yes.
SDGM Sadar Cutter.
SDGM Sadar Cutter.
Okay.
Yes.
And 14.
Petitioner prays for quashing of cognizance and proceeding in the ground of my lord and the compromise, my lord, between the parties.
What are the offences, sir?
307 and other small offences.
Oh, injury?
Injury due to fall, the
Whether grievous?
Grievous, my lord.
Grievous.
Man.
Then you pushed him.
But has been compromised between them and
Compromise is the 307 compromise doesn't mean that because what are the allegations?
allegation? I have annexed 1, my lord. Page 10. Inspector ଥିବା ଡ୍ରାଇଭିଂ ସ୍କୁଲ ସମ୍ମୁଖରେ ସୁନୀଲ ରାଜା 6 ଜଣ ମତେ ଅଟକେଇଲେ, ଅଟକିବା ପରେ ସେମାନେ ମତେ କହିଲେ କି ପକେଟରେ ଦେ and ମୁଣ୍ଡ ପଟାଇ ଦେଇଛନ୍ତି।
Where is the injury report?
Injury report I don't have obtained. I don't have.
How many injured are there?
1.
You have not implemented.
Yes.
He is the informant also. He is the informant.
He is the informant.
I issue notice, let us see. I will not was or may was, I don't know. Let us see. Simply issue notice. Yes. So for the party, but state is accept notice. Next.
17.
Okay.
May I please, Lord? Well, I filed this application, my lord, for quashing of the proceeding. The allegation, entire allegation of the affair, my lord. Hand loan I have taken, my lord.
Yes.
Page 8, my lord, affair.
Yes.
Hand loan I have taken, hand loan I have taken, but failed to refund in the time, my lord. Failed to refund the time for hand loans in time.
Let us see the allegation. Where is that?
Annexed 8, page 8, my lord.
Read it.
My lord. Abhinav Das, କେନ୍ଦ୍ରାପଡ଼ା ଆପଣଙ୍କ ଅବଗତି କରି ଜଣାଉଛି ଯେ 19/12/22 ତାରିଖରେ ପୂର୍ବ ପରିଚିତ କୈଳାସ ସ୍ୱାଇଁ ମୋତେ କହିଲା କୌଣସି ପ୍ରୋଜେକ୍ଟରେ କମ୍ପାନୀର ଠିକାଦାରୀ କାମ କରିବା ସାଙ୍ଗ ହୋଇ କରିବା, ତୁମେ ଟଙ୍କା ଖଟାଅ, ମୁଁ ଦେଖାଶୁଣା କରିବି, ଯାହା ଲାଭ ହେବ ଅଧା ଅଧା ନେବା, ତମ ଉପରେ ଦାୟିତ୍ୱ ନେବି। ତା ଠିକାରେ ବିଶ୍ୱାସ କରି ସ୍ତର କରି ଟଙ୍କା କୈଳାସ ସ୍ୱାଇଁଙ୍କୁ ଦେଇ ଚାଲିବି। ବାଲି ଗୋଡ଼ି ଆଜବେଷ୍ଟ ଘର ଭଡ଼ା ସିକ୍ୟୁରିଟି ପେମେଣ୍ଟ ଦେଇକି ଚାଲିଲି। ପାଣି ଟାଙ୍କି କାମ ମଧ୍ୟ ଆଗେଇ ଚାଲୁଛି। କାମ ମଧ୍ୟରେ ମୋ ଠାରୁ କୈଳାସ ସ୍ୱାଇଁ 9 ଲକ୍ଷ ଟଙ୍କା ନେଉଥିଲେ। ପ୍ରଥମ ବିଲ୍ ଯେଉଁ ସମୟରେ ଆସିଲା ମୁଁ ତାଙ୍କୁ ଟଙ୍କା ମାଗିବା ସେ କହିଲେ ଅନ୍ୟାନ୍ୟ ପେମେଣ୍ଟ ମୁଁ ଦେଇଦେଇଛି, ପୁଣି ପେମେଣ୍ଟ ଆସିଲେ ତୁମ ଟଙ୍କା ନେବ। ଗତ 10/12/23 ତାରିଖ ଠାରୁ ପ୍ରଥମ କିସ୍ତି ଟଙ୍କା ଦେବା ଆରମ୍ଭ କଲି। ଯେଉଁ ଟଙ୍କା କେତେ ତାରିଖରେ ଦେଇଛି ତାକୁ ମଧ୍ୟ ଦେଲାରେ ତାର ହିସାବ ସଂଗ୍ରହ କରିଛି। କୈଳାସ ସ୍ୱାଇଁ ଘରକୁ ବାରମ୍ବାର ଯାଇ ଟଙ୍କା ମାଗିଛି, ଫୋନରେ ମଧ୍ୟ ଟଙ୍କା ଅନୁରୋଧ କରିଛି, କିନ୍ତୁ ଟଙ୍କା ଦେବା ପରିବର୍ତ୍ତେ।
Yes, what do you say?
Here is the present petitioner is a contractor, has taken a work order of ₹2 crores, having no money with him. Therefore, the present petitioner assisted the present informant.
Hey, money.
And yes, that is there. has taken
But
money.
money
and
is not
share the
paid.
50%. That is the condition.
That's right. But
Yes.
what is the criminality in it?
But after taking, when the first bill was credited to the account of the present petitioner, not
Whatever,
refunded.
he has lended the money to him,
Yes.
saying that you have a contract, we will do together and make 50-50.
Right.
That was the understanding.
Right.
And he got the first bill, he is not paid. That's the whole
Crux of the
story.
story.
What is criminality about it?
Facts-
Money dealing,
but there
let him
is,
file a recovery suit if he has paid.
by any good faith, present opposition for not 2 invested and for
Stretch
the
criminal law to that extent. For everything you file a criminal case.
notice ଯାଉଛି ଫେରେଇ ଦେବାର କଣ କେତେ outstanding ଅଛି ଦେଇଦେବେ.
How much you have taken? 9 lakhs.
My lord,
Why don't you pay?
about 7.5.
Don't try to be dishonest. He was your friend. You have taken money, pay it back. That's all.
Well, I have returned only 7.5 lakhs, my lord.
Where is the proof? Show me. Where is the proof? Show me.
Proof is with me, my lord. I could not. I am not.
You show me if you have now, right now.
Yes, here, my lord.
You have taken money, started doing the contract work. When the first bill came, you don't pay.
He used to repay, my lord. I have to repay, my lord.
Get ready to pay the money. Okay, I am issuing notice. Get ready to pay the money. We will finish it up. Okay. The contract work is still going on.
No, man.
There also you have cheated them.
Contract was over, my lord. That was work was completed.
One more thing, your lordship, may
The problem is you have not treated.
yes, your lordship, that is informant not that it is okay to your lordship.
You should have implemented him. Madam, counsel for the petitioner seeks leave of this court to implead the informant in the opposite party number 2. Positive do so within a week. Within 2 days. Within 2 days, the mandatory parties to be filed forthwith. The issue notice to the date of the party by implead him, file the requisites. Yes.
IA is there.
No IA. You have not impleaded him and unnecessary. Incomplete petition. Yes, next. 18. No averment, nothing. I am just giving you by sympathy. Otherwise, you should have been dismissed with cost. See the petition. No averment, nothing. One annexure, 1 page annexure, quashing. You make when you paid the money, what is this? Nothing is written.
No, that's what I am not taking money.
Why should the court will interfere? What kind of petition is this? Asking for stay also. You make a proper averment, proper petition, then only you can get the relief. You have not implemented the party also.
Informant not one on.
Will you withdraw it and file a fresh one with all particular details? That is a better idea because repair work will not work. And you file the proof of the money which you have already paid.
Yes.
That also you do.
Yes.
And I am just allowing you to withdraw it and file a fresh one with all particular details. So that you may get stay also.
Yes,
The petitioners seeks to withdraw the petition to file a better one with better particulars and all relevant documents. With this liberty, the petition is to file it and mention it. I'll take it up. Okay. You have a good case, so prepare, file it properly.
Only prayer,
certificate copy written by replacing. Yes.
Petitioner challenging the action of the OP number 4.
OP number 4.
Gold items, my lord.
What is
pledged item? I have annexed 4, my lord. Similar order may be passed.
What has he done? You are making allegation against the police officer. What have you done?
Notice ଦେଇଛନ୍ତି ସେ ଯୋଉ ornaments mortgage ଥିଲା ତାଙ୍କ ବ୍ୟାଙ୍କ ରେ ଫାଇନାନ୍ସ ମନ୍ନାପୁରମ୍ ଗୋଲ୍ଡ ଫାଇନାନ୍ସ ଲିମିଟେଡ୍ ରେ ସେଟା ହଉଛି ଚୋରି ଜିନିଷଟା ଏଟା ଜଣ ନାଚିଂ ହେଇଥିଲା ସେ ଏଫଆଇଆର ହେଲା ପରେ ଏଟା ସିଜ୍ ହେଇଛି ବ୍ୟାଙ୍କ ରେ ମର୍ଗେଜ ଅଛି ତାଙ୍କ ସେ କହୁଛନ୍ତି ରିଲିଜ କରାଯାଉ ମାନେ ୱିଦାଉଟ୍
not to seek adjournment required produce before the court, trial court. This is the only prayer, and I have an
what are you showing me?
Annexed 4, my lord.
4.
Page number 25.
Relevant page 27, lordship, your
27.
Yes, your lordship.
Yes.
That is their lordships in another case, your lordship directly.
My lord, I legal case, my lord.
The company can be partner for But these facts are different, bro. What is your case?
Yes, my lord. My lord, in this case, not different, my lord. They are according to section 90 to 92 of the BNSS. They cannot seize the gold ornaments. Only
Tell me the facts. How the facts are.
we are ready to furnish
for the moment your lordship FIR was lost by one.
People are saying some sentence, one sentence. You think
No, lordship. I am kindly glance for a moment the FIR, your lordship. FIR was lost by one. Lordship, I Raji lordship is against the unknown person lordship. And in that affair, she alleged that from her neck the necklace was snatched by some unknown person. Accordingly, the said seized stolen materials was mortgaged by before the Mannapuram Gold Financial Lordship.
By whom?
That is the lordship. That is the
by one person,
another person lordship.
Not the accused.
Not the accused.
Not the accused. Lordship.
Brother of the
yes.
What is it?
Yes.
Now they are saying
the police has issued notice to produce before the stolen materials before him for purpose of the investigation. That notice is
to this financial institution.
Yes, your lordship.
Yes.
Under that, the said notice is under challenge by my friend, your lordship.
Petitioner is the petitioner is one of the non-banking financial institutions. It has the non-banking financial institution. The petitioner is agreed by the notice.
Yes, your lordship.
Annexure 1.
Notice,
issued by OP number 4.
1 minute. Let me understand. I will do it. Don't wait. If you speak, then I get confused. Better that I will do myself. Right. Petitioner is agreed by the notice dated 24/3/2025. Issued by the opposite party number 4 under section 94 of BNSS 2023 for 23. It is the reading of the notice reveals that the opposite party number 2, the IIC of
Bodabazar Police Station.
Bodabazar Police Station has summoned the financial institution, that is the petitioner, to produce the gold ornament mortgage with the bank by who has mortgage?
Brother of the accused person.
Brother of the accused in FIR number case number 128 of 2025. 2025. The present petitioner is seeking the quashing of the page notice. The counsel for the petitioner has relied upon the order of the spot dated 3/3/2025, passed in CRLMC number 137 of 2025. So in 2025, Messrs. Manapurna Finance 27, page 27. Finance so versus State of Orissa. The petitioner submits that why you are only the financial institution taking all
stolen
materials on mortgage. Earlier also you were this doing same thing.
My lord.
What no?
We are KYC is there. We are making.
You are indulging in this wrong practice. Anyway, Submits that the petitioner was had confronted into similar situation in another case, and he had the petitioner had approached this court by filing CRLMC number 137 of 2025, where the order dated 3/3/2025 has been passed. He seeks a similar order. Similar. Relevant would be to reproduce the order dated 3/3/2025. Now, regard Mr. Monty, submits that the case of the present petitioner, case of the petitioner is the field of the facts of the case in CRLMC number 127 of 2025. Regarding that to the submission made by the parties to bar, the petition is disclosed of the direction to the opposite party number 2 to request the banks for production of all the stolen articles which are under the mortgage of the petitioner as and when required. Required either before the court, as and when required to be produced before the court. The bank is so the petition is also directed to dispose of for transfer or auction the alleged stolen property, not dispose of, transfer or auction the alleged stolen property till the trial is concluded. With these observations, the petition is disposed. Yes. Yes.
Bodobazar PS Berhampur. Bodobazar PS Berhampur.
Berhampur. Bodobazar PS Berhampur. Yes.
19.
So, it's question of the proceeding on NII. But the question of the proceeding on 138 NII. The facts of the case that originally a vehicle was financed in favor of the DW1. He is the co-villager of mine. And he became defaulter to pay the EMI. The finance company, the present complainant, the agent of that company proposed me to take that second-hand vehicle because he failed that to pay the EMI. The finance company took possession of that.
How do you purchase that car?
And proposal was given to me to purchase that car. And in favor of my wife, the loan was to be sanctioned. I agreed to their proposal, and being the guarantor, I issued the check. That is, thereafter, no vehicle was, neither the vehicle was handed over to me, nor the ownership was transferred in my favor of my wife.
Have you complained anywhere?
Yes, ma'am. The entire evidence starting from page 28.
What is evidence where?
Yes, starting from page 28. The
20?
Page 20, running page 28. The evidence statement of the complainant is filed.
And what is the stage now?
At this evidence is closed. At this stage of argument, NBW has been issued against me.
NBW issued for what?
Because for non-appearance for the single days.
I'll set aside that. Go and appear. Where is that order?
Entire evidence shows.
Where is that order? I will not appreciate the evidence. Evidence is already going on. That court will deal with that.
Yes.
Show me the order by which.
At page 18.
18.
Order dated 38/24.
30?
38/24.
I'll set aside this.
Yes,
madam. Although the petitioner has by invoking the jurisdiction of the court under 482 CRPC, the petitioner seeking quashing of the entire 160 case number 19 of 2022. So initiated by the opposite party against the petitioner for the offense and settlement of the NIA. The evidence of the complaint, opposite party number 2 in the complaint case has also been closed, and the matter is of the big end of
Evidence from all sides closed.
the evidence. The matter is the big end of the trial. At this stage, due to the absence of the petitioner, what is that order? Order you said 23.
Order of imbue. At page 18, the order dated 38/24. It starts from page 17. Order of cognizance is 21/11/22, and NBW order of NBW is 30th August 24.
Petitioner, the KNFC Rajpur by PCR issued NBW against the petitioner in ICC number 1CC number 9. The petitioner is also agreed by I am not inclined to entertain this petition seeking quashing of the entire criminal prosecution as the trial has to get advanced stage. However, the NBW issued against the petitioner on 30th 2024 is set aside, subject to the petitioner appearing before the court on or before 30th of April. Yes.
I will.
My lord, here the proceeding is under challenge. My prayer is to pass the proceeding because the proceeding is still pending 2014. Till today, nothing has been done. Only the allegation is there was a mass agitation against that CDA, that by the slum dwellers, they are also making agitations to release their landed property.
When the charge sheet was filed?
Charge sheet has not yet been filed, nothing.
What is this then, annexure 1?
That is the proceeding, sir. Only proceeding.
Annexure 1.
Sir.
But charge sheet already been filed. That document, alleged document.
Yes. Charge sheet has already been filed.
So confidently you are saying no?
Yes, sorry.
Your first annexure is that.
Sir. Sorry, sir. Charge sheet has been filed, but thereafter nothing has been done. So 16.
Yes.
Also, here is the offense is also 307.
On 29/12/2014 FIR. Charge sheet filed on 7/10/2016.
Plural number of accused persons are there, Your Lordship. And here is the case number 307 and 3 PDPP Act and 7 Law of the Criminal Law Amendment.
What is happening in the trial front?
That part I have no instruction whether it is in charge has been already framed before the trial court or issue process has been started. That part.
Last occasion also, my lord also directed to take instruction.
Wherever it says that nothing.
But I am
Wherever you said.
No, that I have not stated in the petition. Then I got the instruction from my client.
No, you have the charge sheet. You say that you have charge sheet.
Sorry, actually, that is
why should the court will believe you?
That is available.
You show me any averment in the petition that after 2016 the charge sheet filed, nothing has happened. Show me anywhere in the petition. Then I'll intervene.
Let me know.
No. Why should you make out the case? You have filed the petition,
sir.
Where is the averment that after 2016 charge sheet is filed, the trial is not proceeding, nothing has happened.
Sir.
Show me anyway.
Yes.
Then I issue notice, otherwise no. If that is your case, then you have to make a averment. Anywhere one sentence.
My learned senior claiming that though charge sheet filed on 16 not have been proceeded in the matter, let it come from the learned trial court whether the learned.
Why should
I'm not
do exercise?
Yes,
in his case, he has to do it.
Yes, Your Lordship.
At least he should make an averment.
That is right.
Have you made any amendment anywhere?
Just sir.
I'm listing it just, or I file an affidavit stating what is the state,
Yes, yes.
whatever.
Yes,
After 2 weeks.
Yes, yes.
22.
Yeah, the husband is before your lordship. The entire set of family members have been implicated in a case under 498A and 4DP Act. Now, this is vis-a-vis an order under Annexure 1 at page 15, where a cell phone recording was sought to be given for forensic investigation. That the learned trial court has refused. If your lordship would see page 15, that's the impugned order.
The application at your instance.
At my instance.
Okay.
And they say that the right to page 17, the learned trial court says that since it would breach the right to privacy, they are not inclined. And in a very peculiar manner at page 18, they say that since the Honorable High Court had pressed hard for timely disposal and it's a targeted case, I'll not allow. So this is our last chance now to get this conversation on board. And if that conversation actually...
What are you thinking about the conversation?
In that conversation, in the cell phone conversation, there are recordings between the wife and her parents that there was no cruelty. Then there is an important conversation between the wife and her alleged affair with a third person, where she is constantly requesting that kindly take me away from this.
Who has recorded the conversation?
The phone had that.
Might have deleted that also.
No, that's there. The recording is there. All that we are saying is you take this recording for forensic lab tests. Matching the voice should match that of the PW4 and the recording. So if that matches and if that comes into record, then the truth will be out in the open. The entire case will be proven. There, my lord knows that judgment of the Honorable Supreme Court, that every case, the objective of the trial court is actually to find out the truth.
What is the prosecutor say? Is it the application moved through prosecutor or simply sit on the you filed?
No, we have filed. Accused defense has filed.
Where is the pleading? Let us see. What are the objections? Where is your application? Let us see. I think it is 44. Page 44.
Page 44. Annexure 6.
What are you saying?
My lord, may kindly see paragraph 2. We have given entire details.
Whose phone number is this? Is it seized?
Yes, yes. It's seized. It's a part of record. We have.
Where will I get that it is seized? See, your allegation is your wife is in conversation with one Sudar.
Yes.
You say that there is a paramount.
Yes.
Then unless your wife's phone is seized and that paramount's phone is seized, where is the question of recovering of the conversation? How will you get it?
Now, my lord.
Where from you will get it?
It is not in dispute that that this phone is not the veracity of the phone is not.
Where from I'll get that this conversation is there, existing.
It is there. It is there. We have given the entire transcript before the court. We have given the phone to the court.
Where is that? Somewhere it should be there. Passing this order will create problem then. No, you will after his life.
No, my lord, may kindly see.
Show me where you have said or anything from in record that the conversation between the wife and the so-called paramount in their phone number is preserved, which could be sent to the voice expert.
Now, my lords, may kindly see the specific prayer at page 49. The phone with the IMI number, everything, to send it to file. It's not that we want to take this phone on record. The phone is before.
That seized?
Yes, it is before the court. So just the last step has to be taken. The transcripts are there, everything is there. Only the last step they are reluctant to send.
extraction of the data stored in the device
Yes,
and to record the voice of PW so and so so on.
my lord. And if the voice matches,
Who is Sarat Kumar Boy?
the father of the of the lady, father of the informant. And this is normally, my lords, these people are not sincere here.
No,
They have taken all steps.
There are 2-3 problems.
My lords.
The first problem is that protocol. The Union of India's, the Defense, Home Ministry's protocol is there.
My lords.
How to follow this protocol.
My lords.
Second is, you want to confront the voice with PW4's voice.
Match
And
the voice.
he has a right to say no. How can the court force?
My lords, if they say no, then my lords, then the adverse inference should be drawn against them. There's one Madras High Court judgment on this point.
Show me that. That's the whole difficulty.
My lords.
That's the reason perhaps the trial court is not able to,
No, the impugned order doesn't say that. Now, before that, my lords, may I just show the Supreme Court judgment? That would throw a lot of light as to how these trials should proceed. Paragraph 32, my lord, may kindly. This is 2012 5 SCC 370.
32.
My lord. Now, my lord, may also, I'll show the paragraphs and then show the background of the case.
Yes, 32. Please read.
The heading is Truth as a Guiding Star in Judicial Process. In this so and so, the court's serious endeavor has to be to find out where in fact the truth lies. Para 33. The truth should be the guiding star in the entire judicial process. Truth alone has to be the foundation of justice. The entire judicial system has been created only to discern and find out the real truth. Judges at all levels have to seriously engage themselves in the journey of discovering the truth. That is their mandate, obligation, and bounden duty. No, these are, this is Supreme Court. That's why I began with this.
These are kind of sermons. Nothing.
My lord, sermons of the Honorable Supreme Court, my lord.
The real point.
No, my lord.
I'll issue notice.
My lord,
because of this.
This is the last chance for us. And my lord, we are facing DV Act.
Problem, see, how can you force PW4 to give your sample and it will be matched with someone?
My lord,
no.
The husband and his entire family, Nonanda, everybody are on the dock. We are facing 125, DV Act, this. And in this background, all that we want is the phone is with them. Just match. If it is true, then the entire...
It's more of a reason, see, being a matrimonial dispute,
yes.
You want to go to this extent
of
recording voice of witnesses, confront with them, and all these things are in a very ugly situation.
The phone belongs to PW4. In that voice...
Check it up whether
yes,
you have seized or not. Seized or not?
Yes.
We'll issue notice.
Yes.
Short date will be able to week forward. Yes. Have you implemented them? Why don't you settle? Is there any chance of settlement?
He went to custody because of this case. It's simpliciter 498A, nothing else. He went to custody. His life is ruined. These cases, my lords, have
custody in 498A?
Yes. And 4 proceedings going on simultaneously. And all that this phone conversation, if it is actually proven, then the entire
Who all are they? 2, 3, 4, 5? How many people you have?
Those are all accused. I'll implead the informant.
You have not impleaded?
No, my lord. I told him, my lord, they somehow will implead it in
these
court.
People are pro forma respondents because they are co-accused with you.
No, they are co-accused. We'll inform. In court, we will implead.
OPA. Parties leave of this court to implead the informant as opposite party number 8. We should notice to opposite party number 8. Opposite party number newly implemented opposite party number 8. We refuse to file within 2 days. Amended of party to file and the service of the summon service of the notice on opposite party number 8 will be also effectuated by the IIC, which police station?
Pottamundi police station. Yes. Pottamundi police station.
Pottamundi police station. Leave the matter on 23rd. 25, yes.
Interim, there should be stay, my lord. Otherwise, the trial will proceed. This would.
Trial, what is this? Is very mistake.
We have already examined the.
Very mistake. Very mistake.
Para 7 of the IM, of the main case.
Very mistake.
Para 7 of the main case.
Yes.
Which would be at page 7.
Yes.
In the meantime, 15 witnesses have been examined from prosecution side and one from petitioner defense side. At this stage, we are bringing this on record. So if this proceeds further,
yes,
we are grateful.
23.
May it please your lordship. My lord, the
If you can make an effort to settle the dispute, let them come. We'll try to pursue it.
May I request my lord to stay this because this adjournment may be a problem.
Stay then. See, these fight is between ego. Your ego and his ego. Getting one positive order boost your ego, and the chance of settlement.
My lord, may limit the stay only till next day.
Later come, we will pursue it.
That adjournment observation may be there.
Bitterly hot.
That adjournment observation may be there.
Yes.
We are grateful.
No, that I'm passing in order. Yes.
May it please your lordship. My lord, the petitioner had.
By the petition.
Yes.
Limited prayer.
Yes, Mr. Agarwal.
My lord, the petitioner had filed a FIR before the Khandagiri PS on 4/10/2023 under section 420 and 506 of the IPC that the accused had taken a sum of rupees 33 lakhs from him and to give a property and thereafter has not returned. My lord,
what do you want?
My lord, my investigation has not proceeded. My simple prayer is that let them conduct the investigation effectively within a time-bound period.
You are the informant.
My lord.
Informant is the petitioner.
Informant is the petitioner.
Petitioner is the informant in Hon'Ble PS case number 424 of 2023. The only grievance of the petitioner is that he has already, when he has filed the, he has lost the FIR on 4/10/2023 against
one Asit Kumar Samal.
Samal for alleged commission of offence under section 420 and 506 IPC. However, the police has not proceed with range investigating these since the FIR is registered on 4/10/2023, it is expected that the IAC
Khandagiri PS.
Khandagiri PS will do very quickly that the FIR is investigated and in accordance with the law. Yes, with these observations, petition is put up. Yes, next.
24, may I please your lordship, my lord. The present application has been filed for quashing of the criminal proceeding initiated against the petitioner on the ground that the dispute between the OP number 2 and the petitioner have been amicably settled, my lord. In fact, my lord, the petitioner is the son of informant OP number 2, my lord, the informant. Family dispute was there, my lord. And
issue notice to
my lord, he is appearing, my lord. OP number.
Yesterday I filed wakalat now.
The so entered appearance on advance.
That 24,
Are they
25.
here?
No, my lord.
Can
Your
you
lordship
bring
may
them
fix.
online?
They will appear, my lord. Your lordship may.
Bring them online at 2 o'clock. I'll finish it up. Why?
Today it's not possible. My lord. Old lady is there, my lord. Open
Online, bring them. They need not come to the court. Online, let them.
They are observe the whole.
Okay, you tell me the.
The lordship may fix up any day. Because similar matter, another 2 matters are also there, my lord.
There are 3 matters.
Give that number. All
Numbers,
the
sir.
matters will be.
Yes.
Today,
Let it be on 22nd, 21st. What do you want?
21st. Yes, my lord.
Give that number. Read this matter along with the matter on 22nd.
22nd.
Yes.
Your lordship, please just come.
Here the item number 24, 25 is the same.
Both are same, my lord.
Both of
24, 25.
And one
Bring
more.
them in the family.
Yes, sir.
Brothers and all.
Previously, I think another
Yes, one matter was there, my
there.
lord. Your lordship may fix it. Well, one small prayer, my lord, in item 24. There is a mistake committed on my part, my lord. The The court has been wrongly mentioned, my lord, typed as SDGM Manugul, my lord. Actually, it is.
There is an item 24 for an accountable submission.
I may be permitted to.
Error. He seeks to correct the typographic errors. What is the error?
That is JMFC Borabala, it's pending, my lord. It's written as SDGM Manugul.
JMC Borabala. You write it down.
My lord.
For the thing. Okay. I just.
I don't want to mention, my lord, item 7-9, both parties present, is the compromise matter. The parties are present before the
Item
court.
7.
7-9.
79.
Yes, ma'am.
Okay. Parties are there?
Yes, ma'am.
What are the offences?
Offenses under section 376 and 2N, my lord. Last occasion, my lord, the affidavit, the compromise affidavit.
79, huh? See. Yes. E76. Cash it filed?
Yes, ma'am.
Yes, my lordship.
Yes, madam.
Last occasion, they filed a joint affidavit, but they have not stated any reason why they are doing the compromise. But today they are filing a joint affidavit. They're stating that the girl is marrying someone else.
What are the allegations, by the way?
376 month.
No.
No, my lordship. The boy, due to the love of my lordship, the boy and girl has gone away and get married, my lordship.
Get married?
Yes, my 164 statement is also there, my lordship.
Boy is 22 years.
Yes, and the girl is 18 years when the time of
Now
occurrence.
this measure.
Yes, my lordship. Marriage, 164 statement.
Opposite party number 3 is the mother of the victim.
Yes.
They are married now.
They are not married. The girls, my lordship, kindly have a glance to the 164 statement. Mo sangere court marriage kariba ko manna karla, mu jabardasti karibaru online registration karla ebang mandir re baha hela. And there is a photo also, they get married. And now what happened? Their parents take away the culture. There is the photograph also, my lordship. They have given.
But there is a registration of marriage.
Yes. That part, how they will.
So how will you get out of
This
In the 164 statement, she has mentioned that we have online registration.
You are married with the accused, registered marriage. And now without getting legally separated.
How it is possible?
You are married somewhere else.
She's not married. She's going
not
to
married, man.
Going to marry.
Yes.
So how will you get out of this marriage? Already marriage, registered marriage.
No, not registered.
Lordship, marriage is not registered, Lordship.
Marriage not
That's what the
registered.
164 says. Online marriage.
Online, they have
Online, but only application there are 30 days. The process is there.
But it's not registered then. Only
Not
apply
yet.
for it. Apply
for it.
Applied for it. Ask the girl. What is there? Okay. 1 week time. Huh? Generally, I don't take it up, but okay, it's all right. It's all right.
No, ICJ is not mentioning so that's
It's all right. No, he mentioned because his matter was already done. Okay, it's all right. All right. No problem.
26.
Yes, sir.
May I please your lordship, my lord, in this case, the appellant challenging the order passed by the Lawrence Special Judge Vigilance Bhubaneswar.
This is the appeal first.
My lord.
Okay. Sentence?
My lord. 3 years.
3 years. Appeal admitted, sentence suspended, and the realization of the fine we also state.
What is this matter, my lord?
The appeal, advance copy.
May I say before your lordship, this appeal should be listed along with the CRLA 265, 279, 281, 304, 335. Because there are 7 accused persons have been convicted.
Okay.
26, all of 25. All of 2020. 265, 279, 281, 304, 335.
Okay. Yes. 27.
27.
2 years conviction.
2 years. 2 years. Same order for the 2 years conviction. Okay. Admitted. Yes.
Okay.
28.
May I please, your lordship? My lord, it's a Belgium matter, my lord. The petitioner was earlier released on bail on 16/11/2022 and subsequently on 17/7/2024, NBW has been issued, my lord.
500.
29.
Your lordship, date of bail is 25/8/2022. The date of issuance of NBW is 17/3/2025.
30.
Your lordship, the date of bail is 27/2022. The date of NBW is 17/3/2025.
500. Yes.
31.
Belgium matter, release on bail on 16/7/2020 and NBW issued on 16/8/2022.
22. 1000.
Madam.
32.
Your lordship, date of release of bail is 25/8/2022. Date of NBW is 17/3/2025.
500. Yes.
33.
NBW was issued on 21/2/2008, my lordship. Bail was granted on 16/1/2003.
2008.
2008
You are there.
NBW.
No, I'm next.
2008. 1500 crore.
34.
Why these NBWs are not executed?
2008, my lordship.
2008 NBWs are not
And
executed.
today also one listed from 98 it was NBW was issued.
So at least if you give little relief, at least people will come and things will start moving at least. That's the idea. Yes.
34.
Your lordship, in 34, the date of bail is 23/5/2000. The date of NBW is also 6/8/2005, your lordship.
2005.
Yes, your lordship.
One step ahead. Okay. 15. 15.
Much obliged.
35, my lordship. Bail was granted on 27/9/1988. And
Wow.
NBW was issued on 14/9/2011.
11, madam.
You can't deny the relief also because you have not executed. What to do? They are coming voluntarily. Otherwise, this will go for another few decades.
Mane 88 when done by the
May I pray, my lord? GR case, my lord, 30 of 1980, a capital B or a small B is.
40 पहले
My cost title or prayer?
the capital B कर दो.
My lord.
Here case number 1988 small b also the capital B.
capital.
36.
Belgium matter, my lord, bail was granted on 18/6/2016 and NBW was issued on 12/5/2023.
NBW
Was issued.
12/5/23.
23.
Yeah.
My lord.
500.
Local bar. Oh.
37.
37 is the restoration application. That is WPC number 21711/2017, which was dismissed.
Yes.
Which was dismissed on 28 February 2020 due to
2020.
20. And the restoration application was filed on 5th March 2000, within 4-6 days after the restoration has been filed.
And it's pending.
Still pending. Today it was released. The prayer for the petitioner is the regularization of his service.
Well, the
And
petitioner
the
is still
council
survived or
appeared-
not, that's the question.
At that time, a council appearing for the petitioner, now you know.
What to do now?
Restore the
Hey, restore if the petitioner is whether petitioner survives.
yes, petitioner.
Who was the counsel?
Counsel is Sumanta Kumar Naik. He was died due to COVID.
Oh. I restore it.
Yes. That within time limitation, it was 5.
I'll restore it because of
No state. It is that the opposite party is the chairman, life insurance.
What I'll do is I'll issue notice. Let us see.
Yes,
Anything survives or not. Issue notice. Huh? Issue notice to opposite party number 2 and 3. Release it after a week. Huh? Who will file?
The petitioner.
Who will file process? Nobody is there. The lawyer has died.
No. I am appearing for the petition. I am for the petition.
You said no now.
No.
Okay, you are appearing for the
Yes.
petitioner. Okay, then I'll restore it later. For the reasons stated in the application, the same is allowed. The writ petition number
21711.
2017.
Yes, ma'am.
It is regularization.
Regular.
Restore to its original file. Lease the matter. Lease the writ petition for hearing before the assignment. Yes, allowed.
Yes, sir.
Yes.
38.
Your lordships, I seek 2 weeks time, my lord, to come back to your lordships because I couldn't get the file today.
Well, the review, they have filed, I have nothing because your lordship will decide whether.
Is there anything there? No, review.
Yes. I do not know because I couldn't get the file.
But I was going through yesterday. I did not find, subject to correction by my learned senior, I did not find anything that will cover under Order 47.
He may make out a case. Yes. After 2 weeks?
Man.
Okay, after 2 weeks. Okay.
Well, I request my senior to serve me a copy of the review petition because I had appeared so.
He doesn't have the file. You have read the file. In his petition, you are asking a copy. Rather, you give a copy now. Whichever you read it.
I would be relieved.
Say that I have read it.
I have read from. I would be relieved to give him my senior a cup of coffee. Then a copy.
Very good.
Exchange copy.
Thank you very much.
Yes.
So this was nice.
39.
My lord, praying for a file of a press requisite by tomorrow.
Sorry, madam.
My lord, praying for a timing for the filing of a
Speak
press.
little louder.
For press requisite for tomorrow.
Requisite.
By tomorrow.
It's not filed. It's
Obliged,
not
madam.
filed. Sorry. Number 1 to 5. 4 and 5. What? 1 to 3. 1 to 3. Within 1 week. Within 1 week, huh? Yes.
Obliged, madam.
40.
May I please, Lord? Now, in this case, my lord, present petitioner pray for the restoration of the petition, my lord. Restoration of the case, my lord, the dismiss.
How much delay? How much delay?
Non-appearance, my lord.
Delay.
My lord, 3 years someday, my lord.
3 years,
Whatever, my
8
lord.
months.
My lord, Corona period in the 19. At the time of Corona period, it's a total no connect between the our conducting council and our
when it was dismissed.
My lord, dismissed 11/2/2020. And that is a precarious condition in COVID pandemic situation.
11 to 20.
Other period contact level.
But they filed on 22nd, 10th.
ताहाँ पर हमू से contact कर रहा है.
24, my lord.
I am a
They
press advocate.
23 also.
She's saying something here.
It was my lord.
When it was filed?
It was filed on 22nd, 10, 2024. 24, my lord. I am saying that they can file 22 also, 23 also, but they filed
They dismissed
22nd, 10, 2020.
My lord, previous conducting council is separate, but he is searching me and I am contacting.
What is the main matter which has been dismissed?
Arbitration appeal, my lordship.
My lord.
34 appeal.
Yes.
37 appeal.
37 appeal.
Is it 37 or 34?
37, my lordship. Appeal is 37.
Due to non-appearance of.
Right, I have seen it. 37.
But 37 also, High Court has no.
Yes.
37 interfere करियो अपन फालतू time.
In appeal also, High Court has no jurisdiction, my lordship, in arbitration.
In this regards, direction हो वाला कथा कि तो non-appearance is so that's why the admission will.
The award amount.
Yes, ma'am.
Yes.
Tell me the award amount. Tell me the award. The cost.
They have not
The
annexed.
cost has to be determined on the basis of the award.
Yes.
The award
Yes,
is very-
yes, madam.
definitely.
Total 4,61,000.
So
Along
it's all-
interest.
How much I imposed little cost?
Yes, yes.
Give how much you will pay?
Your lordship.
20.
10,000, 10,000, 10,000. Huh? Therefore, 534 of 2024. The CMP is CRL, CMP, you know?
Yes.
CMP is suffering a delay of how much? 3 years?
8 months.
3 years. 8 months. Mr. Das informed for the petitioner submits that the arbitration appeal number shown
ARB 7.
8 of
8 of
19 was dismissed in the dismiss on
11/2/2020.
11/2/2020.
20.
That is during the peak period of the COVID. Therefore, the council appealing for the petitioner could not communicate the same to the petitioner. When the petitioner came to know regarding the discussion, immediately they filed the petition. He further submits that the delay is though inordinate, but for the non-communication between the council appealing for the petitioner and the petitioner, the appeal result dismissal. Hence, he fairly submits that the delay may be condoned, subject to terms, subject to terms. For the reasons stated in the application and the statement made by Mr. Das, the delay of so is condoned, subject to petitioner paying the cost of 10,000 to the opposite party. Opposite party, yeah? No, opposite party is government. To the bar.
To the bar.
To the bar, huh? Opposite party. To the bar. To the
Bar library, your lordship. Because you'll purchase the books, that's help for your lordship.
bar will also purchase for the reasons stated in the total is original 5.
5,000 $.
10,000. 20,000 दबागा ना.
ଆମର ଆଜ୍ଞା ମାନେ 71 lakhs କୁ ସେ 4 ଲକ୍ଷ କେତେ କରି ଦେଇଛି ତ ଅଳ୍ପ ପଟ
eventually what will happen is your arbitration appeal will be dismissed.
Yes.
And along with interest you have to pay.
Yes.
Interest is awarded.
Yes.
And you are delaying it, you have to pay the interest. Interest will be more than the
4 lakhs.
principal. I tell you. 37, who will interfere after such a long delay? It is only formal.
obligement.
You are the office wearer and High Court Bar Association.
Still he is negotiating. That's the pain. I should increase the cost, in fact.
In fact, he knows where the money to be deposited in the library.
May I please? Let them serve a copy, my lord. This is a disposal of case.
My lord,
The informant has filed this application. Let them serve a copy. Let it come. I'll take it.
Cancellation.
Yes.
Not cancellation as
there was a
let them serve a copy, my
my
lord.
lord,
Why this petition? Let us see.
Yes.
my lord, there was a
You are the
direction.
informant. You are the informant.
My lord,
Yes. Why are you?
my lord had directed
Agree.
on while disposing of the bail application, para 7.
Para 7.
Yes.
Okay.
The matter was referred to the mediation center, and in mediation center, he had agreed to deposit 19 lakhs 30,000 to the present petition to informant. But till date, he has not deposited that amount, in spite of granting bail by this honorable.
Which para 3 of what?
Para 7, my lord.
Para 7
Para
lakh.
7
Of that impugned order, my lord, 18/9/2024.
89?
2024. I have got that copy, my lord.
Okay, okay. I got it.
Para
I,
7.
my,
Para 7.
my lord.
Yes.
Let them serve a copy, my lord.
What sir the copy? It was sent to the mediation.
Yes, yes. I am agree to pay what amount came to my account, my lord. I am ready to pay, my lord. I have filed
What
a
is the settlement in the mediation?
mediation. There is
I have annexed the mediation
my
report,
lord.
my lord,
Let us
in the
Yes,
IM.
my lord.
Your lordship may kindly see.
IA. Okay. Yes, mediation. Let us see.
In BLAPL number 5887 of 24, petitioner namely Krishna Chandra Chaudhary alias Tukuna admitted that he had received a sum of rupees 19 lakhs 30,000 from Sanjay Kumar Behra and is willing to refund 19 lakhs 30,000 to the informant through DD.
I am ready to repay the same, my lord. I have let them, I will file a compromise CRLMC, my lord. Your lordship quash the application, I will pay the in court, my lord.
Come with that.
Yes, my lord.
Let him come
With that, with that
You are
observation.
interested in your money.
Yes, yes. Yes, yes.
And you file a CRLMC, along with that money you bring.
Yes, yes, yes. Yes, my lord.
What he says that in the bail, if you pay everything, why should he suffer?
Yes.
He'll pay the amount also and suffer the proceedings.
Exactly. That's why I am.
That can't be, no?
Nah.
I put it on 16th. You file CRLMC.
Yes, yes.
Right.
Let it be defect, whatever.
Yes,
tell me so that I can-
let them, your lordship direct to serve a copy, my lord.
The day I will serve.
17th I'm keeping it.
Yeah.
Yes, yes.
By tomorrow or day after you file.
Yes, CRLMC.
CRLMC. And come with the money. Yes.
My lord, I am serving in court today.
Yes.
Wait. My plight before the lordship, I have constrained to file this IA before the lordship. Your lordship may kindly see the order dated 4/10/2024. I have got that order, my lord. 4/10/2024. Passed in BLPL number 5833 of 2024. Your lordship may kindly see.
4/12 or 2/4?
4/10/2000 in original case, my lord. Original bail application.
Yes.
In that case, your lordship granted bail to the present petitioner. Okay.
What do you want now?
My humble submission before, even though your lordship granted bail, it is come to the light while the bail bond has been furnished that one case has been pending within the jurisdiction of West Bengal. For that reason, NCB, they have filed the petition before whether this case is. And till today, my lord, even though this case has been initiated on behalf of the NCB, much prior to the present petitioner apprehension and inside the custody, till today, they have not taken any effort. Your lordship directed to approach for the Hon'Ble Calcutta High Court. My client has contacted, they have stated so that unless until you have released on bail how this case is. Till today, they have not taken any effort to remand the present petitioner to the said court, nor anything has been brought out to the notice of the London court below, my lord. After granting bail, I am inside the custody till today, my lord. Within the jurisdiction of the state of Odisha, my lord.
See the last order, just see.
Last order, my lord.
7/1/2025.
7/1/2024. They have filed the affidavit stating therein that.
Your application is disposed of.
My lord.
Then why this petition?
My lord, why, my lord, I am also filed an interim application for the condition that my wife's condition is serious. Even though your lordship granted bail and observing
that is pending now.
That is the interim bail application is pending, my lord.
Where is that?
That is
IA number?
IA number 112 of 2025.
112?
Because neither I am there nor I am in between.
What is the ground?
Ground, but my wife is seriously ill, by the way. I have annexed entire document before her.
See, the problem is I granted you bail.
Yes.
My lord.
With the condition that subject to verification of antecedent, you will be.
In state of Odisha, there is no
1
case,
minute.
my lord.
One case was found.
Found in West Bengal.
Which is in
West Bengal, my lord.
Thereafter, you moved an application for modification saying that you modify that condition.
My lord. Recalling that condition.
I dispose of that modification application also.
My lord.
Now in the same dispose of application, you move an interim application for grant of bail. What is this?
Because I cannot move.
The petition, how many modifications?
I am submitting before the lordship. I cannot move.
You have to go to the trial court, move the application for interim bail. If it is rejected, then you can come.
Because, my lord, I am submitting before lordship one
When one
Hot
petition is
also,
filed, it is
hot also,
keep on filing applications.
hot also will be there because your lordship granted bail. The court below
I
can.
have granted bail. You are not released because
To
of
that extent, your lordship can be observed. I will find.
You go and move an application
Hello.
for interim bail before trial court on the basis of this document.
Your lordship object to that extent.
The present situation. I think this bail application. Right, order dated 4/10/2024. While allowing application, we case number 583/2024 to petitioner had been enlarged on bail, subject to the condition that she shall be released after requiring the NTC letter. The trial court subsequently says or the trial court declined to release the petitioner on bail, finding that one NCV case is pending in the Withdrawal. Therefore, we approach this court by moving BLAPL number 1112929 of 2024, which has already been disposed of. By the order dated 7/1/2025. In disposal matter, the petitioner has moved an IA being IA number 112 of 2025, taking bail on the ground that your mother is
my wife,
or the wife of the petitioner is terribly ill. The petitioner has also enclosed certain medical to substantiate his claim of entry. Since the matter is already disposed of, I am not inclined to make the application be disposed of. It would be rather expedient that the petitioner should move and separate application before the trial court. Suitable entry direction, relying upon document as has been annexed to file. Accordingly, what is granted to the petitioner to make the application before the trial court. The trial court shall do and to see that the application is disposed of for within 15 days.
Expedition.
Within 15 days.
My man, obliged.
The petition is disposed of. Yes.
Because I am the Hoya. Neither.
So therefore, you move application, 15 days I have given time. They will verify and if you are entitled, you get it. Yes. Yes. Yes, sir.
My lord, kindly see previous order dated 21/9/2023.
Regarding service of notice against open hour 4, the husband.
Sufficient.
Sufficient. But
Yes.
thing is that we have received a report that from 2021 is not available. It is regarding non-execution of NBW. This is the wife.
Yes.
He has filed
That's the wife.
Yes.
Filed the case against the husband. The maintenance order is there. NBW order has been issued.
Why don't you?
So I'm checking. He's not available since 21. This is the report.
Where is he
in the
gone?
village? Since 21. And there are father and mother, they are bedridden. 3 sisters are there. They are not also able to. He has not come to his village since 21. This is the report. And that registered notice, it was received by Prakash Mehra, madam.
There is an order already passed on 24/7/2023.
Notice was issued by registered post. Whether it was received by Prakash Mehra, the husband, or family member. That is to say.
Police problem. So what shall I find it?
3 weeks time was granted to you to execute the NBW.
This is the report, please.
That was on 24/7/2023.
This is the report.
Police report for there is no comment.
So there is a deadlock then. Then NBW is issued, it will not be, you are expressing inability.
Yes.
That is not
If the court of law has issued NBW, you have to do it somehow.
what can be done.
What is the report? This report is 21/9/2023. We are in 25.
Yes, yes. So I have not. I have not.
I will dispose it up with the direction that you should do well to. Because we can't sit here and keep on, the execution of NBW and all.
What is
You have to do it, it's your job.
What is the latest?
What the court will do? Court can't go and do it. You have to do.
Chapter, so that in the meanwhile, from 23 to 25, what is the development?
No, I will not keep it fit.
Upon development ହେଇଛି
କଣ କରାଯିବ ଓପନ ଆଇଲି
ଲୋକ ଆସୁଛି କିନ୍ତୁ ତାକୁ ମାନେ ପୋଲିସ ଧରୁନି
If the person is not available, my lord, other report.
The IIC was therefore this court is of course review that the IIC. Now the IIC might have been changed. It's on 23 new IIC. The IIC Dusuri PS cell. You will to see that the by so is executed without pay within a period of 2 months. Within a period of 2 months hence. 2 months hence. With this observation, I have disposed of the petition saying 2 months time I am giving to execute it. Yes. Unnecessary, why it will be pending?
Yeah, avoiding for that.
Yes.
Before.
Let's item 34 permitted to.
Yes.
44.
That's permitted to withdraw. 44.
Yes.
Can be permitted to withdraw.
Permitted to, yes. Withdraw.
45.
Give the memo on. Yes.
May I please? Two applications on same FIR and also. May kindly see the order dated 23/10/2024.
23/10/2024. Yes.
Notice was issued and thereafter ISS directed to present the opposite party number 2. She was not present. So your lordship directed me to implement all the parties, all the in-laws in. So I have filed another CRLM that is tagged, and I pray for dispensing with the certified copy of the. In this matter, your lordship, divorce was granted. Ex parte divorce was granted in the year 2018.
Who is appearing for opposite party?
No one is here.
Item back. Okay. Yes.
And in the
let us make an attempt to serve through the IIC.
Because order dated 23/10/2024 says that on the repeated approach to opposite party number 2, she has not come before your lordship to argue in the case. Yeah.
After this, we made through IAC.
Yes, already.
Another attempt is made.
In the meantime, your lordship, the husband also died.
Where is the IIC order?
That is 2310 of 24, Your Lordship.
What is the report? Has the IIC served? Has the IIC served?
IIC appeared through VC, Your Lordship, and took time. Thereafter, it did not. It is.
Tell the report.
No.
IIC appeared and he said that request is made voluntarily.
Yes, yes.
Savitri Sethi, yeah? Savitri Sethi. Suchitra Sethi.
Okay. Oh. In the meantime, Your Lordship, the petitioner number 1 in CRLMC 4134 has died. He is the husband of the informant.
Yes.
Died, Your Lordship.
Petitioner number 1.
Yes, husband is died due to cardiac arrest in the month of February, Your Lordship. So all the in-laws are there. So after divorce and this is not
granted.
Divorce is granted. Ex parte divorce was granted in the year 2018. That is at Annexure 5, Your Lordship.
Okay. Okay. Shall I put them in the closet? Nothing new.
Nothing.
Yes, right. The petitioner, the petitioner number 1 is husband of the part number 2. Whereas petitioner number 2 and 3 are the in-laws.
No, Your Lordship, petitioner number 1 in CRLMC 4134.
No, I'm talking about the first. Yeah.
First one is the in-laws, Your Lordship. Husband is not
in-law.
Yes, yes.
I'm on the and who husband is not there.
Husband is not there. In 3916, husband is not there.
Then why have you filed 2 petitions?
As per direction of Your Lordship.
Husband.
Husband and the other in-laws I have filed. Husband is in another CRLMC 4134. He was died in the month of February.
No, 4134. How many accused?
5 accused.
5 accused.
Yes, sir.
Who is the husband?
Petition number 1 is the husband.
In the first 3916.
They are all in-laws, Your Lordship.
They are also in-laws.
Yes, sir. Sister
So
in
total accused how many? How many?
total accused 8, Your Lordship.
8 accused.
8.
Okay, right. The petitioner in both the cases, both the aforementioned cases, are the accused in PS case number. What is this PS case number?
PS case number 164 of 2015. Your Lordship.
PS case number 164 of 2050. After investigation, charge sheet in this case has been filed on 19/7/2016. What is the stage?
Charge not framed till date.
2016. Lieutenant Counsel for the 2016. There are the petitioners in both the cases are made accused. Opposite party number 2 is the informant. The dispute is arising out of a matrimonial discord. Matrimonial discord. The counsel for the petitioners believes that although the charge sheet was filed way back in 2016, but the charges has not yet been framed. Meanwhile, during the pendency of the present proceeding, the petition number 1 in PRLMC 4134 of 2024, who is the husband of the opposite party number 2, has expired. And the rest of the petitioners in both the petitions are the in-laws or the in-laws. The notice was served upon notice was served upon the opposite party number 2. Despite notice, she has chosen not to appear in the court. Therefore, on 23/10/2024, the following order was passed in CRLMC number 3916 of 2023. The counsel for the petitioner has taken me to the Annexure 3. Annexure 3. This is Faisala Nama. Annexure 3, which is the Faisala Nama, invited one, Faisala Nama. On the basis of the said document, he submits that the parties have indeed settled the dispute. Subsequent thereto, subsequent to the settlement, the opposite party number 2 and her late husband, the petitioner in so applied for dissolution of their marriage by mutual consent under Section 13B of Hindu Marriage Act. Hindu Marriage Act. The family judge,
Civil Judge Senior Division.
Cuttack, huh?
Yes.
Family judge Cuttack. By this judgment dated 18/1/2018 in civil proceeding number 470 of 2013 has allowed the application under Section 13B moved by the opposite party number 2 and her husband and resolved.
Pardon, Your Lordship, 13(1).
13(1), yes, 13(1)B. No, 13(1), huh?
13(1).
13B only.
No, Your Lordship, the order.
Written 13.
No, 13(1), Your Lordship. That order says, Your Lordship, the present proceeding under
13(1), but it is converted to 13B, yes.
No, it's ex parte judgment, Your Lordship.
But it's 13B, it is written.
13B application was there, but she did not appear, so that was infructuous. Thereafter, she filed it.
Settlement, right? And the petitioners, the argument of opposite party number 2, and moved the application under 13B. Sorry, 13(1). 13(1) of Hindu Marriage Act. Due to absence of the opposite party, the application has been disposed of by the family judge Cuttack in civil proceeding number 70 of 2013 by judgment at 18/1/2018, dissolving the marriage by an ex parte decree. The ex parte decree passed by the family judge Cuttack has attained finality as the opposite party number 2 has not challenged the same. The present petitioners have essayed the entire criminal prosecution initiated by the opposite party number 2 on the ground that the matter has already been settled. The family court has dissolved the marriage ex parte, and the petitioner, the opposite party number 2, has not challenged the same. Moreover, repeated attempt by this court to serve for the opposite on repeated attempt, although the opposite party number 2 was served, but she chooses not to appear in this court. Besides that, the petitioner also submits that the FIR was registered way back in the year 2015, and subsequently in 2016, the charge sheet has been filed. However, nothing is however, even charges have not been in all the grounds. The petitioner seeks indulgence of this court for working of the entire proceeding. I agree for the state submits that the dispute is arising out of a matrimonial dispute. The developments which has unfolded in the present case is peculiar, and the fact remains that the case is pending since 2015 without any progress, Therefore, there is no legal impediment in giving in indemnity to the present petitioner regarding the information. Yes.
Before minor,
Both the matter questions.
May I please the lordship?
I just minus. On matter item 50,
59.
58.
Okay.
Senior counsel, Mr. Ashok Malti is arguing this, he's here.
50.
Any date may be fixed, 21. No, sorry. He is appearing for the opposition.
I am for the opposite party. So your lordship record, we are ready for the hearing, but we will accommodate. We are ready for the yes, we are ready for the hearing. That is for our client's sake. It may be observed that we are ready for the hearing.
So submit that the senior counsel, Mr. Ashok Malti, therefore, it's an accommodation for a wish. The prayer made by the prisoner is being opposed directly. However, regarding the decide that the senior counsel is not well, the matter is adjourned to 23rd or 24th question.
Well, your lordship be fixed to 29th April.
May I please the lordship? After today morning, one matter was mentioned for regular bail, my lordship. And your lordship was directed the matter will become tomorrow. But it is for a regular bill, and all the regular bill comes serially, my lordship. And they have not filed IA for the interim bill or anything.
You point out tomorrow?
Yes. Yes, my lordship.
There is a standing notice that all the bail matters are coming seriously.
Seriously, my
But the matters number is not come seriously.
You simply tell me, I let it.
Yes.
It is not this bench assigned matter. Let's go to that.
Yes.
English section. Yes,
Dear will not release it. You go into
Yes, my lordship.
It has
There is a standing order.
then simply ask the DR that it was mentioned. He has shown some urgency, therefore I said tomorrow. Let it come.
My lord, item 54.
You should have pointed out that.
But we don't have that file. Now they submit us a file. Your lordship direction, they have submitted us a file.
Give that number. He will go tell the DR.
Yes, ma'am.
My lord, the item 54, it was mentioned for 30th because Mr. Suresh Tripathi, who is the conducting lawyer, he has mentioned it last time.
What do you want?
It may be posted to 30th.
You can't decide the date.
I am
Date will be
requesting.
decided.
I am praying, my lord. Because he
You
will.
decide the date, time, and everything, then everything is upset.
I am praying, my lord.
We'll see. We'll see if 30th can be done.
And interim order may be continued.
Let's see if it can be done.
My lord, item
If you can accommodate, definitely. There is no doubt about it, but depending upon
Oh, President.
My lord, item 47.
you are talking about 54, no?
Yes, yes.
54.
54.
My lord, item 47, my lord. 2 weeks time will be done.
47, it's all right.
Other side is the present.
The opposite party in that case, I would be.
Okay. Agents of the 20. 47, huh? Interim order is there?
No, man.
Then let it come after 3 weeks. Yes. Yes, Mr. Manti, you are.
No, I am not.
Okay.
Don't come, my lord.
Okay.
To mention matter item 77. I'm feeling well. Tomorrow, my lord.
So, case of the 16. Since 10 last 10 years it's pending.
And it's not well.
Again, there is no issue for it. Again,
It is not well.
I think complaint is 70 years old. He's waiting for last 10 years.
It's all right, but he's not well, then you should be,
My lord.
Tomorrow. Tomorrow will be very tough. Let it be on 17th.
Item number.
Don't take adjournment next time.
No,
I think
my lord,
both of us will wish for recovery.
no, more to the end for this and I'm not.
No, you must go at 17.
My lord,
78 million, some other time.
1 minute.
my lord, my advocate is present. My lord.
Don't worry, he's there, he'll take care of you. He has been mentioning, please prepare it. Every time she is mentioning. Are you ready with the
I am ready.
item number? Item number?
100.
Item now weekly 100. Weekly.
Who is appearing from that?
100 ଟା ଆଉଦିନ ଆସି
100.
ଆଉଦିନ ଆସିଲି ଦେହ ଭଲ ନାହିଁ
Call କହିକି ଆସି କାଲି ଆସି କାଲି ମାନେ
କାଲି ଆସୁ ଟିକେ ମାନେ I am not here.
She is suffering for
No,
8
no.
years and the money was never recovered from her at 200 meters away. You understand? She is.
He was working as what? He was working as Tawsildar. We'll do one thing. If I get time, let him give an overall idea about the case.
21st ରେ ଆସୁ so that
Oh, it's all right. Let him give an overall idea about the case. Then we'll see. Huh? Wait, we'll see.
Okay.
Item number 78.
78, you want an adjournment? Okay. Yeah.
17. I can also make all 16.
16.
My lord, I will only take 5 minutes, my lord. My lord, I'll only take 5 minutes to conclude my argument. It is already argued. 81.
Yes, I'll take it at 99. You, huh?
81.
Till you are, see, in the display you have written 99. 81.
81.
81.
I've already argued it, my lord,
Who is-
but I'll only address for 5 minutes. Nothing more than 5 minutes.
No, who is appearing for vigilance? Mr. Das. 81, you are appearing? Okay, I'll reach there immediately.
Okay.
Let us go. Yes.
Bow down. As my lordship pleases.
Item 5.
Yes. 5.
The last occasion, you also sought for a report from the
Yes, ma'am.
DGM. Bhubaneswar.
Report is there. Your Lordship, on the record for it.
Report is there.
Report issued from the SDGM Bhubaneswar.
In spite of orders of this honorable court, he is not compounding disposing of the process. They arise out of a mineral concession development rules 2007.
Your counsel is not present on date of hearing, what to do before trial court? See the report?
Kindly see page 19.
No, I will have to go by the report. The report says that repeatedly your counsel appearing for you is absent. And he has given the date of.
Is filed for compoundment.
Petition is filed by compounding pursuant to the order of the magistrate.
Thereafter, your lawyer have never gone. That's the report.
Now I will appeal and take this.
Not to then direct that I will appear on that specific date and the.
No, you see, you can't file a petition and leave it like that. Just see the report.
You see,
You have a scant respect to the proceeding of the court. And you complained against the court. Court is not deciding. In the one hand, you don't respect the court. And you make a complaint that court is not deciding.
That is my instruction.
Absolutely wrong. You
I'm not the lawyer there.
You tell your client he has given wrong instruction to you. I have asked for a report. The report says otherwise. And your client has instructed you saying that the court is not deciding.
Permit me.
In view of this report which has come, you withdraw.
A specific date, I withdraw.
Withdraw and
You have to permit me.
petitioner by order dated 19/3/2023. 2025. An order was sought from a report was sought from the court from the court of SDJM Bhubaneswar. Bhubaneswar regarding the regarding a short for the SDGM Bhubaneswar asking as to whether as to why the compounding petition filed by the parties on 19/3/2021 has not been disposed of. Pursuant to the said order, the learned SDGM Bhubaneswar by letter dated 7/4/2025 has informed this court that though the application was moved by the parties, however, when the matter was taken up on each occasion, the petition counsel for the petitioner remain absent, and therefore the application for compoundment could not be decided. On the basis of Mr. Pal, learned counsel for the petitioner seeks to withdraw this petition to advise his client to appear before the trial court on the next date appearing. I don't know when the next date appearing is.
Before 30. Honor before 30.
There is no date also. As
Yes.
the case record was dismissed on 10. Oh, then you have to challenge that order. Your application is dismissed on 20th of October 2022 for your non-appearance.
In compounding, how can
But you don't go now, you throw a petition, don't go what to do.
It's a joint petition.
But none of you have gone.
I'm the accused.
But none of you have gone. You tell me one thing, even order 23 application, you know that, order 23 application you move, it is not abandoned. The expression used there is abandoned, just see, order 23. If you withdraw a suit, move an order 23 application, the law is, despite the fact that the expression used is abandoned, you have to appear there. That's the law.
Yes.
And if this is a criminal case, what are you talking? You have to move application, you have to be there. That means both of you throw an application in the court, we have compounded, get lost, we do whatever.
Now kindly visualize one thing. I appear, my lawyer appears or my accused appear. The prosecution counsel does not appear and does not appear.
Then if you have a complaint like that, you bring the entire proceeding, I'll go into it.
No, your lordship,
Better would be to withdraw it.
then I'll withdraw it and move an application again.
You do whatever, I don't know. Because your entire petition is misleading. Making an allegation against the judge, saying that he is not deciding. On the contrary, you moved an application, you didn't go. As a result of which, the application was turned down. Your client has given wrong instruction, complete wrong instruction. What is that? The SDGM also informed the court that on 28/2022, the application moved by the petitioner has been dismissed as none of the parties appeared before the court. in view of the letter dated, in view of the report of learned SDGM dated 7/4/2025, Mr. Paul seeks to withdraw the present petition to resort to the remedy available under law with the liberty and the petition is disposed of. That's a better idea. That's a better idea. I have given liberty that limitation will also take it. Move an application, ask for setting aside and press that application. Yes. Item 6.
May I please, my lordship? My lordship, I want to produce some document.
Yes, madam.
Okay.
What is it?
My lordship, the incident occurred on 4/11/2024, my lordship. And he was in under treatment, means he got an accident and he got a fracture in left hand. So on that basis, the allegation is under section 109(1) and 3(5) of BNS and 25 and 27 of the Arms Act. 2-round firing has been done. My lordship, on that basis, let the CD be called for.
You are, madam, you are saying that on 31/10/2024, the accused was admitted to hospital for some exam.
Fracture in left
So
hand.
therefore, the incident which has taken place when 4/11/2024, he was not there. That's the case.
Hand was plastered and removal also have annexed, my lordship. Removed on 3/12/2024.
Immediately next day he went and did all this thing.
No, he 31/10.
Oh, 12. Okay, 12.
31 October, he got a fracture and removal of the plaster.
Merely because he was having a fracture doesn't mean that he was not there.
My lordship, the
In the
thing is,
fracture and also he can go and participate.
let the CD be called for, my lordship, because he was not present in the incident.
I have I issued notice. I'm not satisfied, but simply I'm issuing notice. Plus, get this happening.
Well, sir, can there be interim can be allowed?
No, I'm not satisfied at all because you are appearing in your personal matters, so therefore I'm.
Item 9. Lordship, the petitioner has filed this RLMC for quashing of FIR against her by the VGR number 34 of 2017, corresponding to vigilance FIR number 30 of 2017, pending before the London Special Judge Bhubaneswar, Vigilance Bhubaneswar, for the alleged commission of offences punishable under section 3(2) read with 3(1)(e) of the PC Act and section 109 of Indian Penal Code. My lord, the background of the prosecution case is that, my lord, consequent upon detection of a trap case against one Pradimna Kumar Parida, General Manager DIC Noyagad, for demanding and accepting bribe of ₹1500 from the complainant in respect of vigilance PS case number 59 of 2016, when his residential house located at Bank Colony, Tagonia, PS Kumbarpada district, Puri, was searched on 13/2016. During search, relevant documents relating to assets, expenditure and income were taken charge, and thereafter.
Who are you?
My lord, I am the wife of the petitioner, wife of Pradimna Kumar Parida, my lord. I am.
Where is the charge sheet? Where is the charge sheet?
Charge sheet has not filed, my lord.
File the charge sheet. Where from I'll gather whether any case is made out or not.
My lord, she is a central government employee. At any point of time, she may be.
How can I quash an FIR registered against you in a vigilance case without even looking into the charge sheet?
No, my lord, in the main case, vigilance PS case number 59/2016, the charge sheet has been filed.
Where is the copy of charge sheet? You file the charge sheet copy.
Some next other day I will file. I
1
have
minute.
document.
Hold on.
Draft case was registered against the petitioner, husband of the petitioner.
Yes.
Consequent to that, search was conducted and number of assets and deposits found in the name of the present petitioner. She has been arrested as an accused under section 109 of the IPC. Her entire income has been taken into consideration. And considering that.
Where from you get it? Charge sheet is not there.
17, page 17, FIR, your lordship.
FIR, let us see the charge sheet first.
Investigation, as per his version, investigation is on. I has gone for the first time. So he is seeking for quashing the FIR.
Charge sheet has been filed, huh?
No.
He says charge sheet is filed.
In the main case, business.
Let us see the draft case. Okay. In this case, charge sheet has not been filed.
This case charge sheet has not filed. This is the
Not
DA
filed.
case. Subsequent registered after several months of detection of the case. This case has been registered.
You just tell me whether in the DA case, whether charge sheet is filed or not.
No, DA case perhaps. The lordship may adjourn to some next other so that I can comply your lordship's here.
Next.
Lordship, date.
I have mentioned you will give a date.
Oh, obliged.
49. $49. This way, you come go. Exchange का time.
Extension of time to surrender.
May I please?
Yes.
Not filed an IA, disposed of case, my lord, filed an IA for extension, your lordship.
And given time for
your
surrender on December 2024.
December 2024, 29/11/2024, your lordship was passed.
Why have you not surrendered?
Lord.
Extension is not routine work. You have to satisfy. You tell me. Why have you not done?
Not no.
What is the reason?
Due to health ground, my lords.
Huh?
Due to health ground, though I have not enclosed any documents to it.
Health ground. What is the age?
Lord, the age is
30 years old and
yes, ma'am.
What was the cost imposed that time?
30 years, lord.
What was the cost imposed? Twentieth April. 20th April. It is made clear that if the petitioner is failed to surrender by 20th of April, the benefit of order dated 29/11/2024 shall be withdrawn. 51.
May I please, my lords? Petitioners.
Why not item 50? Adjournment.
Yes.
51, my lords, my bad. Not a very limited grievance of the petitioner, my lord.
Service.
My lord, in this case, my lord, that is the recall petition has been rejected by the Annexure 7, my lord. That the recall petition was filed by special people on behalf of the informant, my lord. For which, my lord, last occasion directed to implicate the party and issue notice. I also implemented accused as party, and by the lordship's notice was issued. And the first time notice was issued, but he avoided this notice. This order, the matter was listed 6/3/2025, my lords. Lords, kindly have a glance at the order, my lord, where the noting is said that he avoided the notice. Thereafter, the lordship.
Yes. Yes.
The second, my lord, thereafter, PW1, PW2, PW6, the three, my lord, witnesses I want to recall, that is the case 376 and kindly annexure 5, my lord, 3 of SC/ST Act and other offences there.
What are you taking now? What are you taking?
But therefore, I filed a recall petition.
What are you seeking now?
My lord, seek a recall petition because the PW1, PW2 and PW6, my lord.
Where is the order? Where is the order?
That is Annexure 7, page 29, my lord.
PW?
Rejection order.
1, 2 and 6.
My lord.
Yes.
PW1, that is the victim gal, minor gal, my lord, that is the postcode there. PW2, the mother, and PW6, the father is the informant of this case, my lord.
Where
And
is
my,
the application? What are you going to ask him?
my lord,
Ask them. Questionnaires are not there. You have not given the proposed questions also. Yes.
therefore, my lord, short, my limited agreement.
Where are their evidence also? Your evidence also you have not placed.
Evidence, my lord, they have examined to the.
Not filed.
That is the this order process. Permission, my lord. Nothing. PW1 is the
one just forget.
victim, my lord, that is the fact.
Show me the two. PW2.
PW2 is the mother of the victim.
PW2.
6 is the father who is the informant in this case.
You decline cross-examination. And 6 is the.
That is the pressure put for which, my lord, special PP has filed Annexure 7, my lord.
2 and 6 I allow.
Yes, yes.
Okay. Better. Petition is agreed by the order dated 8/11/2024, whereby his application under section 311 CRPC PP has sought.
My lord, that.
You are the complainant.
Yeah, informant. For which your lordship directly will implement the accused for notice avoid kar do che
The petitioner is the informant in the petition. The application moved the special PP had moved an application under section 311 CRPC on 4/10/2024 seeking recall of PW1, 2 and 6 for re-examination. The said application has been turned down by the trial court provided in order dated 8/11/2024. The petitioner is agreed by petitioner being the informant in the present case is agreed by the same and also the same in the present petition. The accused persons were implemented as opposite party, and notices were issued to them or him.
Him.
Accused
him.
Notices were issued to him by the order dated 2/1/2025. The through normal process the opposite party number 2 oblique the accused has been served, and despite that he is not to appear. Therefore, on 6/3/2025, the IIC Kaukia PS has been directed to serve the opposite party number 2 oblique accused, despite service through IIC Kuakai PS. The opposite party number 2 is not to appear in the proceeding. Hence, not appearing. And also for the petitioner, Mr. Nayak appeared for the state and permits that he supports the claim of the petitioner for seeking a recall of the 3 witnesses, namely PW1, 2, and 6. The certified copy of the testimony of these witnesses were handed over to this court. Perusal of the evidence of the witnesses reveals that insofar as PW1 is concerned, he was examined on 9/4/2024 2024 and was subjected to extensive cross-examination, by the defense counsel. Defense counsel on 24/9/2024. Insofar as the PW2 and 6 are concerned, they were examined they were also examined on 9/4/2024. However, the cross-examination has been cross-examination by the defense has been declined. Even in the examination in chief is also appears to have not satisfactorily done. Therefore, the application moved by the PP, the special PP, assigning the reason in the application under section 311 deserves merits insofar as PW1, PW2 and 6 is concerned. In any case, recalling of a minor witness, namely PW1, repeatedly is barred under the statute, namely under the provisions of section 33, bracket 5 of POCSO. Therefore, the prayer made by the special PP for recalling PW1 is not entertainable. Moreover, she was extensively examined and cross-examined, and she suffered cross-examination. However, so far as PW2 and 5 are concerned, the petition deserves merit. Economic same is allowed. The trial court is directed to summon PW2 and 6 by fixing a particular date and particular date. The prosecutors should conclude the examination in the date to be fixed by the trial court, and on the same day the witnesses on the same day the defense counsel should also conclude the cross-examination to this state witnesses, and the circulation and direction which is allowed.
53.
Extension of time receipt order dated 3/3/25 receipt.
Date was 23/25.
25 for 26 April.
Receipt.
No further.
55.
Yeah, please, your lordship. Here, my lord, I am challenging the order dated 24/8/2023, my lord, passed by the London Additional Civil Judge Senior Division by Annexure 6, my lord. In this case, the petitioner is the plaintiff.
Annexure 6.
My lord.
Notice, sir.
My lord, notice and appeared, my lord.
Yes.
My lord, in this case, my lord, petitioner is a plaintiff and opposite parties are the defendants, my lord. Plaintiff filed a suit for declaration of right and cancellation of sale date, my lord. In the said suit, the defendant appeared and filed their written statement in the year 2005, my lord. In the year 2005 to 2023, they did not file any counterclaim, my lord. After so many years, they filed a counterclaim. The plaintiff filed objection, my lord, that this counterclaim is not maintainable because he has not filed the counterclaim in their written statement. When the written statement filed, they should have filed the counterclaim along with counterclaim. But at that time, they have not filed any counterclaim. In separate, they have filed a counterclaim and which is not maintainable. Though the plaintiff
counterclaim by way of an additional written statement.
No, amendment, my lord.
Additional written statement.
Additional written statement because on the ground that the plaintiff filed an amendment petition that was allowed, and thereafter they filed an additional written statement.
When the initial written statement is filed?
My lord, initial written statement filed, my lord, that is in the year 2003, five, my lord.
Give me the date.
My lord, 28/2/2005. 2005.
And counter claims?
Counter claim filed, my lord, 24/4/2023.
Show me the counter claim and written statement.
My lord, the counter claim is annexure 4, my lord, page 42.
Yes.
That they have mentioned, my lord, in paragraph
40?
42, my lord.
Yes.
Counter claim.
This is application under order 6.
My lord, they have mentioned the nomenclature as order 6 rule 7. Sorry, 17. But in the averment, they have stated the counter claim. With lordship's permission, my lord. If your lordships kindly see the paragraph 3, my lord.
Yes.
The defendant states that written statement filed by the defendants need to be amended for the just and proper decision of the suit. Therefore, it is prayed that written statement filed on behalf of the defendant may be permitted as per amendment provided in the schedule below.
He is seeking amendment.
No, my lord. Thereafter, my lord. Thereafter, schedule amendment, my lord. ବାଦୀ ମାନେ ମକଦ୍ଦମା ଚାଲୁଥିବା ଅବସ୍ଥାରେ ବିଭିନ୍ନ ସମୟରେ ବିଭିନ୍ନ ଅର୍ଜି ସଂଶୋଧନ ଦରଖାସ୍ତ ମାନ ଆଗତ କରି ମକଦ୍ଦମାର ପ୍ରକୃତ ବିଷୟବସ୍ତୁକୁ ସ୍ପଷ୍ଟ ଭାବେ ବର୍ଣ୍ଣନା ନ କରି କୋର୍ଟରେ ବିଭ୍ରାନ୍ତିକର ପରିସ୍ଥିତି ସୃଷ୍ଟି କରୁଥିବାରୁ 1 ନମ୍ବର ବିବାଦୀ ତାଙ୍କର ଖରିଦ ବୃତ୍ତିର ସୀମା ନିର୍ଦ୍ଧାରଣ କରାଇ ନେବା ନିମନ୍ତେ ଏକାନ୍ତ ଆବଶ୍ୟକ ଅଟେ। ବାଦୀ 2240 ଖସଡ଼ାର ପୂର୍ବ ତରଫରେ ଦଖଲ କରୁଥିବା ସ୍ଥଳେ 1 ନମ୍ବର ବିବାଦୀ ଉକ୍ତ ଖସଡ଼ାର ପଶ୍ଚିମ ତରଫରେ ତାଙ୍କର ଖରିଦ ଖତିଆନ ଅନୁଯାୟୀ 4 ଡିସମିଲ୍ ଯାହାକି ସରଜମିନରେ 2 ଡିସମିଲ୍
What do you want?
My lord,
This is amendment only.
my lord, they have mentioned in the counter with lordship's permission, my lord, in paragraph 7 of the schedule of proposed amendment, they have made a prayer, my lord. So my lord, in paragraph 18, my lord, in the schedule amendment.
Yes.
ଆମେ ବାଦୀକ ପ୍ରାର୍ଥନା କରୁ କି? So this prayer should not be added as amendment in the written statement.
What is the prayer?
ଆମ୍ଭେ 1 ନମ୍ବର ବିବାଦୀଙ୍କର ଖରିଦି ଖାତା 154 ଖସଡ଼ା 2240 ଖସଡ଼ାର ପଶ୍ଚିମ ତରଫ ଖତିଆନ ଅନୁଯାୟୀ 4 ଡିସମିଲ୍ ଯାହାକି ସରଜମିନରେ 2964 ବର୍ଗ କଡ଼ି ଉତ୍ତର ଦକ୍ଷିଣ ଲମ୍ବ 152 କଡ଼ି ଦକ୍ଷିଣ ତରଫ ପଶ୍ଚିମ ପ୍ରସ୍ଥ 20 କଡ଼ି ଉତ୍ତର ତରଫ ପ୍ରସ୍ଥ 19 କଡ଼ି ଏ ରୂପ ଏ 2964 ବର୍ଗ କଡ଼ି ଚୌପଦୀ ଉତ୍ତର ତରଫ 2219 ଏକ
decree ଦିଆଯାଉ।
My lord.
That is the prayer. That is the content.
My lord.
Who is appearing? Is appearing? Nobody is appearing.
No. My lord, suit is of the year 2004, my lord.
Call him. I'll dispose it up.
That
why is your suit? I'll pass over. Let's see.
My lord.
Just see if you can bring it. I understood it. Yes.
56.
On behalf of Mr. Siddharth Das, kindly adjourn this matter. On behalf of Mr. Siddharth Das, kindly adjourn this matter.
Adjourn on behalf of Mr. Siddhartha.
7.
Hon'Ble.
On behalf of Mr. Raut, my lord. Please pass over.
Pass over this 3 that. It may not reach. Yes. Pass over. Yes.
59.
Pass over. Who is appearing for opposite party? What do you want?
Petition copy.
Are you ready for hearing?
No, petition copy, ma'am, submit.
Then copy of counsel appearing for opposite party submits that he doesn't have the copy of the petition. Counsel for the petition undertakes to supply the copy during the course of the day. Leaves the matter after 1 week or 2 weeks. 2 weeks. Yes. 58. Yes. Interim. Yes.
59.
May I please, madam? The petitioner is the husband and the opposite party number 2 is the wife.
their marriage was solemnized and thereafter the marriage was dissolved by decree of divorce on mutual consent. I have filed that order, and prior to that, a GR case was pending. For that reason, the petitioner filed this CRLMC to quash the order in view of the payment of permanent alimony to the wife, as well as the clause it has been mentioned.
What are you seeking here?
Hello?
What are you seeking?
The quash the GR case pending before court of.
What are the grounds?
Grounds, the mutual divorce has already been granted.
If you read.
Last few months, I have no connection with that fit to this for betterment and both.
IAS, yeah, notice the thare jai.
Don't go at least for the opposite party and submit that last couple of months that he has not able to contact the opposite party. Therefore, he requests for issuance of press notice to the his client, through IAC. IAC, which police station?
Police station.
Cuttack. Mahila police station.
Jagatpur Mahila.
Jagatpur. Cuttack. Jagatpur. IAC. After 1 week. See, mutual divorce has already been granted. If she's not taking interest, then we will quash it. 498 and all.
We have no
2010 FIR. What will you do with this?
Instead of Jagatpur, Jennapur station, the district of Jaspur, Jennapur police station.
FIR is Cuttack, na?
Mohila PSS, but she is now, the address is given in the Jennapur station, Jaspur district.
Jennapur.
Care of Ajay Kumar Kanti, Norajpur, post place Jagatpur. Now present residing.
Jagatpur. Book the week for Rakho. There are 2 weeks to ask. Yes.
Date me fixed.
Date fixed.
Yes, he'll pick the date.
60.
Your quashing of negligence in a proceeding under the NI Act, Lordship. And Lordship, kindly
opposite party.
Opposite party, local Dalta Thilik. It's appeared Lordship, item 60, opposite party.
Yes.
Videndra Kumar Mahapatra, somebody.
Yes.
May I argue? May I argue?
What are you seeking? Quashing?
Quashing of
You are the accused.
Yes.
Ground?
Ground Lordship, Lordship, kindly say, prepared debt chart, everything is there. In fact, no offense is made up. Money is there in my account. Fraud has been done. It is fault of the bank. And Lordship, because account there is money, sufficient funds were available with the bank, Lordship, in my account.
What is check amount?
Check amount, Lordship, 1,61,000, Lordship.
You don't dispute that you have issued the check?
No, that I have never issued, Lordship. That also I have never issued. That's why, Lordship, I have, on the relevant day, funds were there, and it's foul play by this opposite party.
These are two contradictory antitheses.
No, that is there, Lordship. Lordship, kindly come.
I had money in the account, so therefore no case is made out.
No, I'm not saying that. I'm not saying. Lordship, kindly see Annex 3 for a moment. I prepared a dead chart. If I go sequence wise, it will be better to convince.
Let us see the reply to legal notice.
Lordship, Annex 3, Lordship, kindly see page 3, the dead chart, Lordship, for a moment, Lordship. Lordship, go to page 3.
Have you replied to the legal notice?
Lordship, in fact, Lordship, he has not replied to the legal notice.
Then come to the complaint.
Lordship said.
Come to the complaint.
He has not filed complaint petition, Lordship. Yes, Annexure 4.
Yes, come to the complaint. Yes.
Lordship, page 32.
Yes.
Facts of the case, Lordship. That the complainant is a senior citizen lady. On the occasion of marriage ceremony of her relative in the month of July 21, the accused came in contact with the complainant
and exposed himself as a branch manager of IDBI Bank. The accused gave assurance to provide bank loan of rupees 20 lakhs from IDBI Bank for renovation of a house with less documentation process, with a condition that the complainant will give rupees 1,70,000 for the advance the loan processing fees, and accordingly with faith upon the accused, the complainant had given cash of rupees 1,70,000 to the accused in presence of witnesses. Then that after taking the said amount of rupees 1,70,000, the accused failed to keep his assurance and unable to provide the assurance loan amount of rupees 20 lakhs. That on several requests made by the complainant, the accused did not turn out. Lastly, in February 22, with interference of the local gentries, the accused issued a check bearing number such and such of 1,61,000 lordship, drawn on the State Bank of India Dharmagad branch, district Kalahandi, duly signed by the accused in the favor of complainant to fulfill his debt and liabilities, and also refunded check of rupees 9,000, cash of rupees 9,000 only. These are the facts, lordship. Then that on 18/22, the complainant presented a check through his banker, ICICI Bank Limited, Barmunda branch, Bhubaneswar, for collection, which has been returned unpaid by the banker of the accused for the reason drawn signature before. The complainant received another information from his banker by number such as memo note such and such, lordship. So the signature did not match, that's why, lordship, it is
And see, Paratri,
lordship.
after receiving notice, you say that I'll
No.
rectify the thing.
That is a wrong statement, lordship, that I can from the death chain.
How will I know that?
No.
Your no will be proved in the trial only.
No, lordship. Lordship, on the ground of the ingredients as available under the provision, lordship, it is strictly not applicable to my case, lordship.
How?
Lordship, I can demonstrate, lordship.
It is demonstrated.
Yes, lordship. Lordship, then lordship, kindly come to death chat, lordship. So that is the enter.
Death chat where?
Death chat, lordship, that is just page 3.
Page?
Page 3, lordship.
Yes.
Lordship, lordship is absolutely, I can complete the para 3 and 4 also.
I
Then
read it.
3, 4, then lordship, I will complete.
Complete date chat, I read it.
Lordship.
Understood. Yes.
Lordship, lordship, I'm Roman 3, I'm reading, lordship. Roman facts, Roman 3 and 4, I'm reading, then I'll come to death chat, lordship.
Yes, read it.
Lordship. Then thereafter, the complainant had issued a statutory legal notice through his advocate by rest of
I read that paragraph, next paragraph.
Next, lordship. Then thereafter, as per request of the accused complainant, once again deposited the said check. Lordship, this is very important.
Yes.
The same check has been deposited once again on 4/5/22 with his banker ICICI such and such, a return unpaid by the banker of the accused for the reason item listed twice. There is no question of insufficient funds, lordship. The bank has, lordship, written the check on the endorsement, lordship. It has been listed twice. For us, there is no provision to submit the same check twice before the bank, lordship. That is the finding of the bank.
Yes.
Then the complainant received the aforesaid information from the banker memo number such and such. Then, lordship, next para. That again the complainant issued a statutory legal notice through his advocate on 25 and 22. The correct address of the accused asking him to pay the check as such and such to him in 15 days. Then, lordship, then subsequent events came and then he has filed a complaint petition, lordship.
Yes.
So here, lordship, kindly for a moment, can come to provision first, lordship. Where under this circumstance,
If we just come to the
the check, lordship. Lordship, page 3, lordship. Lordship, just I have given a incident of 2021 first, lordship. A false allegation has been made regarding interaction of the petitioner and opposite partner complainant in the capacity of branch manager of IDBI Bank.
Come to the relevant part. These are story clear. This
No, I have only
21,
I have made
21,
out of their allegation. I have given only this reference are out of their allegation, lordship, not my story, lordship. Lordship. It has been alleged interference, lordship.
So these are your probable defense. Come to the
Lordship.
point.
Lordship, kindly come to 18/2/2022.
Yes.
The complainant presented check through his bank, ICICI Bank, Baramunda, for collection. Then, lordship, on 21/2/22, check cleared and rupees 1,61,000 transferred for petitions SBI account, Dharmad, to the account of the opener 2, lordship. The said amount transferred, lordship, to his account.
Because where from I'll get these facts?
Lordship, that is, I have given the interbank, state bank account, lordship.
So all these things has to be Adducing the evidence.
No, Lordship.
I am trying the offense.
No, I'm not. I am on the legal points, Lordship. I am on the question.
Simply tell me what is the legal point.
Legal points.
All these facts, this had happened, that had happened.
When there must be ingredients of insufficient.
What is 138?
Lordship, kindly listen. 138, Lordship.
138.
I have quoted Lordship in a petition, Lordship.
Yes.
Page 5.
Let us come.
Page 5.
Okay. Yes.
Lordship, page 5, 138, I have quoted Lordship.
Yes. Tell me.
Where, Lordship, page 5, Lordship.
Yes.
Where any check drawn by a person.
Which part you tell me?
Lordship, para 5, Lordship, page 5, 1, and the
No, which part you are relying upon?
The first paragraph, Lordship. Itself. The ingredients are there, Lordship.
Which ingredient is lacking in your case? Simple tell me that.
Lordship, there is no insufficient funds. So how can we, Lordship?
It's not necessary. Or then your case is, if it is insufficient funds, then only 138.
Definitely, Lordship. Insufficient
Where
funds.
you are reading that?
I am reading the Lordship provision of law. 138, Lordship, kindly see.
Yes.
138. Where any check drawn by a person on an account maintained by him with a banker for payment of any amount of money to another person from out of that account for his discharge in whole or in part, or any debt or other liability, is returned by the bank unpaid either because of amount of money standing on the credit that account is insufficient to honor the check, or that it exceeds the amount arranged to be paid from the account by agreement and with the bank, such person shall be deemed to have been committed an offense and shall without prejudice with the profit there. So there must be the basic ingredients, Lordship. There must be insufficient funds. Here there is no allegation, and there is no scrap of paper to disclose before Lordship or while before taking cognizance before the learned court below that on the relevant I had insufficient funds. So
that is the reason that 138B is there.
Lordship, again I'll convince Lordship.
No. 138B, once notice comes to you,
Lordship,
and you have to say, on that day I had money.
Lordship.
Unless you say in your reply, 139 operates against, then you face the trial. That's the scheme of law.
No, Lordship. Lordship.
What is no? That's the law. What can you do?
I'm not disputing, Lordship.
That's the simple law.
No, that is not simple law, Lordship. Simple.
Why have you not replied to the statutory notice? That is the reason the statute provides an opportunity. In the first opportunity, you have to say that in the account money was there. You go and deposit. If you don't do that, 139.
But here, Lordship,
reduce to 114 evidence.
No, that's true, Lordship. But here, Lordship, kindly see. Here I am harping, Lordship, you are just giving emphasis on the ingredients of the provision itself. Then, Lordship, it is hopelessly barred by law of limitation.
It is once the check returns,
Lordship,
if referred to dry or for X reason, Y reason, it is presumed that there was no money. Therefore, 138B is provided. 139 operates again. And you have now discharged the pardon. Think that on that day money was there, so therefore ingredient doesn't take.
That's why my debt chart is very important, Lordship.
Debt chart I read it.
No, Lordship.
I read
completely. Lordship, I read out. Lordship, perhaps I can convince you about Lordship.
I read it. You want to read it, read it. No problem.
No, Lordship, what I'm saying, Lordship.
I am there exactly with the debt chart.
No, Lordship, what has happened, Lordship, in this case, if Lordship, to the ground really. In fact, these persons were reading at Bhubaneswar. While reading at Bhubaneswar, usually they were begging, Lordship, or they're borrowing some money, some of the persons, Lordship. Be one of them, Lordship. Lordship, kindly be with. At the relevant time, while giving some money, they are in return.
These things are really matters in these days?
Yes, Lordship.
No.
Reason being, Lordship.
482.
Reason being, Lordship.
482.
That's why, Lordship, I am giving the simple.
I need to conduct a full trial. I'll have to call, examine.
I will rely upon the judgments of Supreme Court.
So many.
Lordship, in fact, Lordship, kindly grant me one adjournment, Lordship.
No, I'm not with you. Then
no, Lordship.
Don't say all this.
No, Lordship, with great respect, Lordship, I don't have that available, Lordship. I can convince.
What is the proposition of law?
Lordship, this is hopelessly barred by law of limitation. They have filed the complaint petition at a much later stage.
Let us understand the date.
That's why the debt chart. Lordship, kindly see the 18 to 22 first date, Lordship. The check was presented on 18.
No, the second deposit.
I come to second.
Second deposit on your request.
Lordship, kindly come to second, Lordship. Lordship, on 25 to it is signature defer, it came returned signature defer, Lordship. Then, Lordship, on 2022, information regarding drawer signature defer. Then on 25, Lordship, Lordship, on 4/5 and 22, Lordship, carries. On 4/5/22, the complainant once again deposited the same check with his banker. So, Lordship, first my submission, this deposit also without knowledge of the petitioner. It has never been noticed to the petitioner. Lordship, then second, Lordship, on 6/22, bank communicated to him regarding again, Lordship, because it listed twice. So it is
come to 4/5/2022. The complaint opposite party once again deposited.
Lordship.
And the averment in the complaint is on your request you deposit.
Where is the document, Lordship? Where is my request?
That is the
Lordship, once.
Why are you not appreciating it?
No, Lordship, one thing after appreciate one thing, Lordship. Lordship, kindly appreciate one thing.
There is a specific averment.
No,
Lordship, notice was issued. You received. Thereafter, you said that you deposit once again.
There is
deposited.
Lordship,
kindly. There is a limitation.
No, Lordship. There is tricky, Lordship. Lordship, kindly appreciate one thing, Lordship. Lordship, kindly see what is the finding while Lordship taking a note that
you file a written note.
No, Lordship, one thing, Lordship. Lordship, perhaps I'm not clear. If Lordship clear one line, Lordship, then Lordship fully convinced, Lordship. The first time Lordship check returned due to signature defer. Had it been a case, Lordship, if my agreement there,
sir, I am on a 482. I can't say that this might have happened, that might have happened. You have to,
Lordship, Lordship is relying upon the
complaint says it was this written signature defer. Notice was issued to you.
Lordship,
you said that deposit once again. That's the averment. What can I do?
Averment there, Lordship. Averment.
I have to go by averment, complaint, averment. What are you talking?
Lordship, averment. How can averment, Lordship? How can Lordship kindly appreciate one thing, Lordship? Once signature deferred, can it be a check or the same check will be?
The averment says that you told after receiving notice that please deposit once again. He went.
How can once the bank endorsement says my signature defer, how can you present it twice, Lordship?
But that's what the averment. Then you
then this averment is wrong.
When he
that's what I'm saying.
When he'll step into the witness box, you confront that. That's the law.
That is completely separate thing.
No, that is the only thing. Not separate.
Here, let's say time for questioning of cognizance.
That's the only thing.
On the point of law.
Okay. Okay, you file written note.
Lordship, kindly post it second day. I'll convince before court. Then Lordship will give it. On the second day, Lordship, kindly.
I am fully convinced.
No, Lordship. But I am unable to convince your Lordship.
No, you
may be convinced in.
No, you writing lawyer. What are you talking?
Lordship, if I will be
tomorrow.
Tomorrow, Lordship.
No, tomorrow. I will forget otherwise.
Tomorrow, Lordship, the Lordship matter. Let it Monday.
Day after.
Monday.
Okay, Monday.
Tuesday.
Okay, Tuesday on your request. Okay.
And I got the points, Lordship. How can you convince?
I hope I shouldn't forget.
Sorry, grateful, Lordship.
Okay.
I will able to convince Lordship.
Come with the judgment. After arguing, don't say.
Because that's why I'm taking adjournment, Lordship. Because I don't have the judgment. Lordship, grateful.
And junior counsel says that Supreme Court has said, I can understand.
No, Lordship. In fact, Lordship.
And you argue after half an hour and you say Supreme Court has said, Supreme Court has said.
With the great respect, Lordship, I have not gone through the brief thoroughly, Lordship. That's why the whole.
You see, standing at your level, you should come with judgments and tips you have said. Young lawyer can tell that.
In fact, Lordship, I remember.
We generally accommodate the young lawyer.
Fixed another matter, first case of Paras in list. I have prepared in that case, Lordship.
All right. Tuesday, no problem. Come with the
grateful.
And better come with a written note if you want.
On the Sunday, I'll come. Not interim to continue.
Okay, very well. Yes.
Interim to continue.
Interim. Don't send your junior.
No, Lordship, I'll come. I'll attest to Lordship. A great opportunity to argue with Lordship.
Yes, next.
62.
Challenge to the cognizance order on two grounds. Firstly, there is no sanction being taken against the petitioner under section 197, though by the time the charge sheet was filed, he was retired, so not necessarily the 19th permission is not required. So assuming 19th permission is not required, 197 sanction has never been taken. and the law, lapsing and other things. Now, leaving that aside, the total fact doesn't constitute any offense against me. May I just take your lordship to that very brief narration in the charge sheet? It's at page 127. Let's come to paragraph page 127. That's the charge sheet I'm annexing.
Yes.
My lord, second paragraph. This is the fact.
What
actually.
is stage now?
The stage is the cognizance charge has not been done.
Charge has not been framed.
No.
2010 charge sheet.
At the instance of the co-accused person,
Other co-accused not been.
including the present petition.
How many?
No, I have not.
How many accused? How many accused?
I have not taken any stay. Why you at my instant
There
are saying?
There are 7 accused persons.
Okay, they are absconding.
No. Of course.
They have filed petition before December.
3 of them have now been quashed. my lord.
Stay.
Interim order.
No. The proceeding against them has been quashed. Anyhow, my lord, that's different. But I'm just on the merit that absolutely everything considering in this case that nothing is there.
Now, where is that they are proceeding quashed?
Yes,
Which
for the
court?
quashing of the other proceedings.
My lord, I'm coming, my lord.
Do you have the order?
I do have. I have make mention of everything. Just I'm not trying to draw your lordship's attention to the fact that then we'll go there. May I just tell lordship at page 127, paragraph, second paragraph, beginning with the
127?
sentence on the following day.
127, huh?
Yes, my lord.
Yes.
On the following day, both the proprietor of the following day, that is on so and so, both the proprietor of the above unity again filed a separate applications to the general manager DIC for empanelment of their respective units with OSIC with supply of the coal. On the same day, that is on 20th June 2009, the concern filed both the unit were processed by Manoranjan Bisoi IPO. Let's kindly hold it. Manoranjan Bisoi IPO, and then the dealing officer in charge of raw material section of DIC in his noting mentioned that both the firms are working EMI 1 registrations recommended for allotment of 4,200 metric tons of coal in favor of the said only. It is submitted to Sadasiv Rautray. Sadasiv Rautray is me, my lord. Sadasiv Rautray, the manager raw material DIC. On the same days, Sri Rautray, raw material manager, directed Nursinga Charana General Industrial Supervisor of this office to report the annual requirement of the coal as per the project report, requirement of the coal as per the project report submitted in EM1 registration. CNC Jana, then the industrial supervisor simply gave the noting that so and so on the same day.
What are you trying to draw out of it?
So, my lord, I am drawing that Manoranjan Bisoi, but there are 3 layers. Manoranjan Bisoi put up the file to me. I not put up it to the general manager, Srikanta Prusti. Now, this person, Manoranjan Bisoi and the general manager, both were then serving. Sanction was asked for, denied. I am just forwarded the file. That's the total case against me. Since I am retired, therefore I am here. And both of them, the cognizance was taken and it was challenged and passed.
Where is that order? That's what I'm
That's what
Manoranjan and the
Manoranjan
below you. Officer below you and officer
below you, me is Manoranjan, officer above me is Srikant, and both the orders are here.
Show me that. On merit it is got?
For sanction, the government has not given sanction, my lord.
No, that's a different story now.
No, yes.
In your case, sanction is not recorded.
No, my lord, my case is this, my lord. The DIC, there are 3 officials involved. Because I was retired by that time, therefore sanction was never asked for. The persons who are there at the time of filing of charge sheet, against them the sanction was asked for. The government said no case is made out. Hence, in spite of that, since the cognizance was taken, it was quashed. Now, my role is a third one because I am retired, no sanction was accorded. So, whether I am on the same footing or not, that's for your lordship to decide. That's number 1. Number 2, even otherwise, 197 sanction is not there. So, I am taking, I can get the benefit of lapsing. So, all these, it is Manoranjan, na?
Yes, Mr. Marana. How do you reply?
Page 140.
2 officers you
sanction was refused on that count, it was quashed. As far as this petitioner is concerned, he was retired, so 19 is not required.
That's right, but
as far as 197 is concerned, whether it is required or not, that is a matter of trial.
Why?
That is the,
but see, in so far as Manoranjan is concerned,
my lord,
you are officers, competent officers were declined to give sanction because there is no case made out. The same material. The middle officer who has forwarded it, merely because technically he is stuck, you will prosecute him.
No, 197 is also there.
No.
So your lordship can see page 40.
40?
148.
148.
Last para.
Yes.
What has happened in this case? They all have conspired with each other and recommended.
But your department says that there is no conspiracy.
Yes.
That's the reason sanction is not granted.
So far as conspiracy or not, that is that department is not to any case at any case it has been refused. So on that count, it was the case is gone in against them. So far as this petition is concerned, other accused persons are there. The entire case will not go because it's a case of a huge fraud and involving all have conspired and they recommended in respect of a fake non-existing funds.
My lord, this is what the rejection order for the sanction. What?
It is also, you also can see page 148, the DIC officer, last page, last part. The DIC officer, last part, 148. The DIC officer, without observing any procedure formality, recommended for empanelment of fake and non-existent SEPA immunity of this case.
That is, my lord, second pushti. The DIC official comprising of 3 persons. One is Manoranjan Bisway, the other one is the petitioner, the third one is the general manager. Second pushti. So these 3 are from DIC, then OSIC and other. So the DIC were 3. And they say the DIC officers are colluded each other. But the government in the refusal sanction say there is no criminal conspiracy. That this is how it is being refused.
That is
because I'm retired, therefore I will be here. Because I'm retired, therefore I'm here. Otherwise, there is absolutely no case against me. Because I have only forwarded what is being put up to me by IPO. What is being put up to me by IPO, I have forwarded it to GM. And general manager is the person who has taken the decision. GM has taken the decision and
cannot discharge his duty in that way.
Yes.
He is not a post office. He will simply.
Yes, nobody has done it in the post office manner.
He is a higher officer and law says something otherwise. He carries more responsibility than lower officers.
Now, who is lower officer?
Lower officer, in respect of which those have, on the basis of their recommendation, this petition has recommended for the sanction.
What is his job? He is forwarded or recommended?
Forwarded, not recommended. Forwarded.
Let us see.
That's
the DIC officer, got it.
Yeah,
that is empanelment of fake and non-existing SM immunity of this case, declaring them to be working and without any inspection or capacity of assessment of the unit recommended of highest quantity of coals within the capacity of general manager. This page
a general manager, exactly.
DIC has prescribed in the coal policy on the government of India, so and so. OIC officials, OSIC officials, having connived with the COD operator, allowed him to operate freely, violating the terms of agreement so and so. So those harms are completely non-existent at all.
No, all these things are correct. I am not on that. But what
what
is bothering me is you have not given sanction insofar as general manager is concerned. You have not given sanction insofar as Manoranjan is concerned, who is superior authority. And in between, this officer has only forwarded it.
No.
Merely because by the time he retired and they prosecuted.
No. This petition is hired to them. He has recommended.
Hired to Srikant Pushti. Certainly, Srikant Pushti is the general manager. I am the regional raw material manager.
Who is general manager?
Srikant Pushti.
Capacity of general manager.
Srikant Pushti.
Where is the raw material manager means he carries more responsibility.
Where is
because
Pushti sanction?
Refused and I have given the order.
No, that is admitted.
That is admitted.
No. What are the material? What do they say? They say that
they say in that paragraph, my lord, I have reading at 127. They have categorically stated.
What are you, by the way, manager? What is your designation?
Raw material manager.
Then you
IPO put up the file saying that he has verified and EMI 1 registration is there and their requirement is 4200. The language
of the refusal sanction order is on recommendation of the manager, that is he, and the general manager, DIC, recommended the case of OSIC for empanelment of the coal consuming SMSC. As such, there is no sufficient evidence against Manoranjan Mishra, ex-industrial promotion officer, regarding the criminal conspiracy with other officials of DIC and OIC and private contractor in allotment of the coal to the fake SMSCs. This is
So
what.
if he is the raw material manager, he carries more responsibility. He must have
And
prior
Madam,
knowledge
the
whether
Shrikant
the industry
Prusti-
is operating or not. Because prior to that, he must have supplied the raw material.
What is the
raw material
who are supposed to have field inspection meeting and
Well, as per the 2007 policy, it is the general manager responsibility. General manager, whatever general manager will forward, that will be empaneled and the
quorum. I'll get to all these things. You place all these things on record.
My lord, that's the 2007 policy and already
This the sanction order and
my lord, I'll
everything
place. I'll place.
file an affidavit and
my lord,
explain it and do it. And give a copy.
Yes, ma'am.
You have a case if you can, because facts are so much, it has to be, separate.
As far as Manoranjan Mishra is concerned, the order was passed in my absence without hearing, with all fairness.
Challenge it.
Challenge it.
And I have recommended for challenging it.
Have you challenged it?
Department, I have to obtain that instruction.
You get that?
2021, my lord, it is been.
It was heard extensively.
See, it would be unfair on the part of the prosecution to prosecute him, leaving the two other main people.
Since he was acting as a raw material manager, he must have knowledge regarding the field.
What about general manager?
General manager must not have the knowledge.
The
IPO doesn't have the knowledge, general manager doesn't have the knowledge, only manager, because I have retired by that time.
So, raw material manager, kamo houchi, this is dekhibo whether that
Code
industry
ଲେଖା
is
ହେଇଛି ଆପଣ
operating because he
ଏଇଟା କୋଉଠି ଚାର୍ଜ ସିଟ୍ ରେ ଲେଖା ହେଇଛି ଆପଣ ଚାର୍ଜ ସିଟ୍ ରେ କୋଉଠି ଲେଖା ହେଇଛି ଦେଖିବା ଏଇ ଜିନିଷ
I'll show it.
Let us see. Yes.
Obliged.
64.
May I please, madam? Let it know next week, madam. One vital document which has not been collected, madam.
Lieutenant Counsel for the petitioner seeks to file additional document, please. Yes.
66.
I beg your lordship, last
That yesterday,
the death cat and the judgment of last I have been Khan judgment and Rosalind. It only resonates on your lordship's legendary judgment that the adolescent relationship and there is a stark distinction between exploitation and adolescent relationship. And the present case is in the.
I've already passed some order.
Yes.
I dictated the order.
Your lordship was wanted when the appearance of the petitioners exempted. I have given that on 16-1.
Given dictation, already given dictation.
Late of the Vagatila.
Appearance.
16-25 ରେ personal appearance
16-25
ଥିଲା ଦେଖିଦେବେ
କରିଦେବ ଆଉ ଏଇଟା ଦେଖିଦେବ।
I have put your lordship's order was. Well, I have given the judgment and
judgment of the court.
Diplo black.
Yes.
67. My lord, I have appeared for the respondent number 1 in this case.
Yes.
And I have not received the petition copies. So the same may be supplied.
Send to registered post if somebody is associated present.
Do you have any associate here in the court premises today?
No. No.
Yes. So
No.
how will he give? He already send you the copy through post. Somebody has to receive it from his office.
Twice
Send
I have
someone who
filed
can
the
go and
requisites.
visit it, huh?
Twice I have filed the requisites.
No. Lieutenant Counsel appealing for the Mr. Ramit Chandra Pradhan appealing for the opposite party number 1. Submits that he has not received the copy of the petition. Mr. Arthur, the counsel for the petitioner, submits that he has already sent twice the copy of the petition through post. Next, on behalf of the opposite party number 1, somebody may collect a copy of the petition from the officer. Please the matter. Entry
Interim
mortem.
order. Yes.
Entry mortem continue. You collect it from his office. You can't keep on sending through post. Yes.
68. Yes.
State my lord, kindly take around next week, my lord. My lord, Mr. Maharaj is out of station, my lord. He is appearing. His name has not been reflected, my lord.
Let him complete the sentence.
My lord, last day, the same plea that he is out of station, the date may be adjourned.
My last occasion not reached, my lord.
My lord,
Last occasion matter was not reached.
Problem is there is an interim order.
Adjournment application next Wednesday, my lord, it will finish.
The court can't accommodate according to your convenience.
One day last chance, my lord. Next Wednesday last chance, my lord. He is out of station.
Interim order fine nature.
That is the reason for difficulty.
Adjournment.
That's the reason I am very reluctant in giving
My lord, Tala court,
interim order. Better that you dispose it out. This way or that way. That's the best way.
Tala court case टा सरी वाले भी जानता कारण तांकिरी टंका से मो पाखरु नहीं चली शेयर मार्केट रे लगे बोली नहीं क्या दो ना 70 लाख टका नहीं आई चली मो ता सेम्बो डिटेल अच्छा
ये कुछ वाला देखो
क्या बोल रहे थे
we'll see, we'll adjust it.
Yes.
Week or so. Yes, next. 69.
70.
सेट करिए एडजस्ट ना
Next week. Yes. 71.
71.
May I please, Your Lordship?
Yes.
There is a dispute between the doctor and the advocate regarding the position of plot. Prior to coming to this case, Your Lordship already passed a judgment in case of counter case. There is a case and counter case. Your Lordship straight to come to page of mine 20.
Yes.
Page 20 of my brief.
Yes. Yes.
Then Your Lordship's observation is that
In the cross case.
Madam, cross case. Come to a finding that this is in civil in nature.
In that case, you are the complainant.
I am the complainant. He is the accused. 2 cases have been initiated.
No, this is not a cross case. No. And there is absolutely no.
Complete
Sir, पचास level कहली मुनि जिन जो कही नहीं.
Then there is no compromise, nothing of that.
No.
Merited.
I am placing one second, my lord, refreshing Your Lordship. What my senior saying, so that is incorrect. 2 cases have been initiated by the present petitioner, so also by the opposite party. The present petitioner case has been charge sheeted. The opposite party case has been torn down by the investigating agency. There is no clue for that reason. Final report has been submitted. Against that order, against which I am the complainant, informant, they have challenged the cognizance order, citing that the present status of the case. That has been reflected also in the present case, my lord. What happened? While this case has been taken up by Your Lordship, the present petitioner, on behalf of the present petitioner, it has been submitted that there is no case has been pending against the present, but by the present opposite party against the present petitioner. After passing of this case, in order to file a protest petition in shape of that final report against the final report, he has initiated a complaint case, stating that in that the entire allegation which has been depicted in the FIR. And after quashing of this case, he has come forward to the court before the learning court bureau, adduced the evidence and filed the complaint case, stating the allegation which has been depicted earlier in the FIR. Same thing, my lord. And a cognizance has been taken after initiation of the complaint case without filing the objection regarding the protest petition, nor there is any allegation that why the final report has been submitted, because there is no clue that has been appointed by the investigative agency. So where is the question that this is not a case of case and counter case?
Yes.
I am submit.
Yes, sir.
Your Lordship, may kindly turn to page 6 of my count. My objection.
See, the order dated, my order, in para 7. I just come to para 7. In para 7, I have said that the FIR being so-and-so, corresponding to so-and-so, registered by the petitioner against opposite party number 2 and adjournment for creating hindrance for installation of the iron gate in the plot resulted in the closure report. Okay. The police, after the investigation, have found that the dispute is purely a civil nature. However, the FIR number so-and-so case has been resulted in a file form. The petitioner contends that if the cross FIR from the same incident initiated by him is resulted in the closure report, that means that there is a cross FIR. This is a cross FIR. And I have passed this why and
Your Lordship,
civil dispute is going on.
no, not the civil dispute. Your Lordship will kindly see the injury report in respect to the present petition, the opposite party number 2.
323.
With respect to the present OP number 2.
Yes.
And your Lordship may kindly to see page 6 of my objection.
What is the injury? Injuries are very pain in abdomen. I have been pain in left shoulder.
There, he has been assaulted.
Assaulted is there
And,
pain.
and no.
323.
He has been assaulted. Your Lordship will kindly see this para 13. He had one admission.
Para?
Para
13 of what?
There was a 144 case. This is his admission. Para 13 mechanism.
What is the document?
It was a so-called notice in a 144 petition.
That is civil case which has been initiated.
Admitted that the police has asked him to enter into the land forcibly and ultimately your Lordship will consider. Para 13 mechanisms. That also I have given in my objection. I have quoted in my objection. Police asked him to get grass into the land and all other things can be there.
What is the civil case pending?
Civil case, that civil case is not pending. 144 petition was there. There he has taken that stand that police has asked him to enter forcibly into the area, into the land.
Your Lordship, may I see their petition? Their petition in previous case.
I can't read like this. 482 petition. You are passing on some document. He is passing some
I have
document.
given in my objection.
Decide the case.
I have given in my objection that
That has been reflected in paragraph 6, my
There
lord.
is no chance of according to you, sir.
that is for him to contact him. I cannot say him.
Your Lordship, paragraph 6 of the Lordship judgment. That has been reflected.
I think you should.
That is for him to contact the.
Just asking
number. That is for him. I can.
It's all right. There is no allegations are very
With that extent, my lord, I am submitting with. And ask in their case.
Otherwise, file their document and decide.
My lord, that has been reflected.
It is
That is
341, 440, 323, 294,
my lord.
354, 506.
I have lost against them. 354 outraging that has been molested. Everything allegation is there for that in charge. Your Lordship, they have submitted. There is a civil case pending before the learning civil judge junior division. How my senior is saying so that I could not be. Fast court Cutter bearing civil suit number.
That's what I have recorded also.
My lord. That is their submission. How he has denied so?
I have recorded that.
My lord, paragraph 6, page 22.
Yes. I have recorded that.
My lord. Civil suit number 859 of 2009 between the parties regarding the
civil dispute pending in the civil judge senior division first class in Qatar hearing civil suit number 859 of 2019. This is suit pending.
But it is a criminal liability.
Suit is pending.
Maybe. That doesn't mean that he will enter and assault somebody.
I'll decide it. Okay. You file all documents, whatever. Yes.
Obliged.
Yes.
I will also submit a note for them.
Yes. Meanwhile, if you can settle the dispute, you tell me. Otherwise, I'll decide it. And there is a recent judgment 2-3 days back.
Apex court. That is.
Yes.
You cannot take that civil case into criminal case. That has been
see that judgment.
EP case. Obliged.
That's I filed this directly to my office. The JMFC has rejected my protest petition, where the final form had said that this is a false case that are filed. If I may,
service.
The notice had been served.
There is a protest petition.
There was a protest petition.
Your protest petition is rejected.
My protest petition is rejected.
Where is the accused? You have not implemented the accused.
Well, it's because money was taken away from my.
That's not the issue. Issue is if you agree by you are the informant. Your protest petition is rejected. Then why have you not implemented the
Well,
accused?
I do not know who the accused is. Well, if I may show, if I know, okay, what has happened is on 31st of December 2025, when I went to the SBI.
And you don't know the accused, how against whom the trial court will take cognizance?
In the final form, they have written the name of the person to whom the money has been reportedly transferred.
You implead it. Because a final form is filed, a right is accrued in his favor. Your protest petition is rejected, then he is entitled to be heard.
Please. Well, I'll take steps to implement the.
Okay, let us call for the petition is to implead. LA is accused. LA is the opposite party number 2. He is aggrieved by the fact that his application, his protest petition has been rejected by the court below. Let him implead the LA is accused as opposite party. You can notice the opposite. Yes.
73.
May I to submit on behalf of Mr. Naik, my lord. Yes, earlier occasion also, my lord. And see ordered at 3125, my lord. There are lordship, my lord, directly state council to obtain the case theory.
Yes, my lord.
But there are 2 cases, my lord. Same occurrence, my lord. Initially, police lodged the information. Accordingly, law and PSS 145 registered. While investigation is going on continuing, my lord, second FIR filed by the mining manager, my lord. That order I have challenged, my lord. The cognizance taken. None of the witnesses stated anything against any person, man, implicated any person, my lord. Only because they are involved in 145 case, my lord, earlier case, my lord. I have not challenged that case, my lord. That is it, my lord. The second FIR, my lord, they cannot be registered. One occurrence, there cannot be 2 FIR, my lord. And 2 charge sheet, my lord. And cognizance taken, subsequent taken, my lord.
That will be treated as a supplementary charge sheet.
No, not.
I give it direction.
My lord, there are two, my lord, the charge sheet cognizance, my lord. And if for Jackson, you also to call for the case diary. I can't see once if none of the witnesses stated anything else, how can the police implement the petitions, my lord?
Then that is a different story. Let us see. Yes.
Said that because the 161 statement was taken, my lordship, one of the, I am just reading out.
Yes.
My lordship, kindly have a glance to the statement witness of Muraldharam Matia. He is the security guard, my lordship.
Yes.
May I read, my lordship? Mura Nama Muraldharam Matia was.
Have you filed it or?
No, my lordship.
Anyway,
I think they have filed, I think.
Read it.
Anyhow. ମୁଁ ଉପରୋକ୍ତ ଠିକଣାରେ ରହେ ମୁଁ ବର୍ତ୍ତମାନ କୁରୁମତି ONC ଖଣ୍ଡଧର ମାଇନ୍ସରେ ଗ୍ରୁପ 4 ସିକ୍ୟୁରିଟି ଗାର୍ଡ ଭାବରେ କାର୍ଯ୍ୟ କରୁଛି ତାରିଖ 8/9/2023 ତାରିଖ ଆପଣଙ୍କ ସମ୍ମୁଖରେ ଦେବାର ମୋର ମୌଖିକ ବୟାନ ନେଇକି ଯେ ତାରିଖ 7/9/2023 ରେ ପ୍ରାୟ 6:30 ରେ ମୁଁ ଖବର ପାଇଲି ଯେ ଖଣ୍ଡଧର ଲୋଡିଂ ଏଜେନ୍ସିର 100 ରୁ ଅଧିକ ଲୋଡିଂ ଶ୍ରମିକ ONC ଗେଟ୍ ନମ୍ବର 1 ରେ ରାସ୍ତା ବନ୍ଦ କରିଛନ୍ତି ଯାହାଫଳରେ ବୋଟିଂ ଗାଡି ଚଳାଚଳ ପୁରା ବନ୍ଦ ହୋଇଯାଇଛି ଯେଉଁ ଗାଡି ଗୁଡିକ ମାଇନ୍ସ ର ଭରସୁଆ ଆଡକୁ ଆସୁଥିଲା ସେଇ ସବୁ ଗାଡି ଗୁଡିକ ଅଟକାଇ ଦେଇଛନ୍ତି ସେଇ ସମୟରେ କିଛି ଟ୍ରକ୍ ମାଲିକ ଭରସୁଆ ଟ୍ରକ୍ ଆସୋସିଏସନ କିଛି ମେମ୍ବର ସେ ଶ୍ରମିକ ମାନଙ୍କୁ ତାଙ୍କ ସହିତ ସାମିଲ ହେଇ କୁରୁମତି ମାଇନ୍ସ ର ଅଫିସ ମେନ୍ ଗେଟ୍ ଟ୍ରକ୍ ବନ୍ଦ କରିଦେଇଛନ୍ତି ସେମାନେ ଦାବି କରୁଛନ୍ତି 16 ଚକିଆ ଗାଡି ମାଇନ୍ସ ଭିତରକୁ
ସେମାନେ ମାନେ କିଏ
that my lordship that people who are initiating
how to identify these 20 people those who are petitioners
so kindly have a glance I'm showing one document they're regularly doing like this my lordship
that is one other case registered my lord that's it submitted that case
that not that case from 20
these people they were
their name was particularly written in 2 or 3 statement I have marked it they're named they are saying that 7 number
all the 20 people are there
no. My lordship kindly have a glance I am showing that antecedent they have provided
first of all do one thing the 20 petitioners are there whose names are not reflecting in any statement, you take it care of those names. First I'll quash it, then I'll decide further. Because what happens in these kind of cases, many people. Day you have to read everything and find out.
Yes, madam. In the case I
There are 20 petitions here. I'm sure out of the 5 petitions name might not have come anywhere.
but in the case size, my lord, all the 20 petitions.
Where can be got? What is the evidence telling them? Or the IO might have got his face is not legend, so put his name. Like that. Find out that.
Yes, yes.
At least it's out of 20, 2-3 people will vote for it. Next time, anything in one letter, I'm actually. One 41 actually. Say I think that until I know. Certain session is large. You don't take that. Here in this case, what are the evidence? 161 statement in 161, which you read. 7 clear. I have filed all the 160 statements. Why don't you make it 50? 100
Yeah, I have a number. People.
There actually one case was having that actually discussed. We say, but Ramay Naik is involved in 5 cases, so therefore he is involved in some other cases, therefore he is out. This is no same occurrence of one challenge. Unexpected challenge. Here in this case, what are we exactly? If any witnesses have taken the name of any of them, you sort it out. We will not, if any witness have not said anything, tell me. Read it and exercise. And this can't be anything. Because they are involved in some of the cases. One system falls in another. Where there are 20 petitions.
Yes.
Let it be the and people had 3-1. And then even if you are people are not good to get a
75 minutes. Please.
Sure, I have got the instruction. The investigation is still going on. I was given the letter, my lordship. The charge sheet.
If your lordships will recollect, my lord, the sole issue that falls for consideration here, my lords, is whether a criminal case will at all be maintainable against company officials officiating administrative functions. Your lordships, an earlier occasion concerning this similar case has been pleased to quash so far as the chief financial officer is concerned. Here, my lords, the petitioners are head finance, chief security officer and chief marketing officer arraigned in a criminal case concerning criminal negligence, wherein an accident occurs at the factory premises. These petitioners were officiating administrative functions in the corporate head office, no way connected to the unit factory, nor part of the safety committee of the factory. Neither they were occupier appointed under the Factories Act. Pardon, my lords? If you're not, I am the chief, I am the head finance, my lords. Occupier, your lordships, they are appointed. If your lordship sees, I have filed that committee constituted. The safety committee, if your lordship sees, page 148. 148, annexure 9. The management representatives, if your lordship sees, they are the occupiers, part of the safety committee. Your lordships, so far as the chief finance officer is concerned, if your lordship sees page 155, recording the submission, in fact, the instruction of the state has been pleased to quash the criminal case with respect to petitioner therein. Lordship. Yes, my lords. If your lordship sees 155.
But in 148, my lordship, page number 148, it is only written that the safety committee of the Ferro Corporation Limited Chrome Limit Plan, Bipinagar, Randia, is hereby reconstituted. The immediately following employees have been nominated as the office bearer.
How many petitioners are there?
My lord, there are 3 petitions, my lord. 3 sub-items, in fact.
Okay.
They are head finance, my lord. And the second one is chief security officer. The third petitioner was working as chief marketing officer again. Remotely, my lord, they cannot be said to even have played a part in that negligence.
Maybe security officer, maybe
My lordship,
some extent, maybe
yes,
involved.
my lordship, kindly have
Marketing officer and
yes,
finance officer.
my lordship, kindly have a glance to N of the Factories Act.
To
N of the Factories Act.
Yes, 2N, huh?
Yes.
Yes.
May I read you?
Yes.
Oh, here the definition of the occupier. Of a factory means the person who has ultimate control over the affair of a factory, of the factory. And provided that in the case of 1, 2, and 3, my lordship, soft class 3, my lordship. In the case of a factory owned or controlled by the central government or any state government or any local authority, the person or persons appointed to manage the affairs of the factory by the central government, the state government, or a local authority, as the case may be, should be deemed to be the occupier.
What do you say about the petitioner? One after another.
3 of the petitioners are the taking care of the current affairs of the whole factory, my lordship. So they are the responsible.
No. Ultimately, control over the affairs of the factory means the accounts officer, the marketing officer, whoever is
They
there.
are the head of the factory. They have to take care of the safety and security of the factory, my lordship.
There is a safety, the technical staff will be responsible for that.
My lordship, maybe.
What the account officer will do?
My lord,
what is happening in safety?
No, my lordship, maybe they are also responsible for the safety, my lordship. But that part, we have not taken the instruction because the investigation is going on.
Individually, you have to tell me how a finance officer or a marketing officer is responsible for safety. I can understand the security officer maybe to some extent.
But there's the
security officer, why security officer is important is he has to see whether a particular employee is going to a restricted area or not. Those things he has to look into. He has to control that.
Yes.
To some extent, he has a role.
Yes.
But what about the accounting officer? He might not have seen the factory premises. He must be working in his office.
But they are the
And a marketing officer might not have come to the manufacturing unit at all. He must be working somewhere. How will you make them responsible?
My lordship, let the investigation is going on. Let them file the charge sheet and we will see.
You file an affidavit saying what is their role.
Yes,
and I can understand insofar as the factory security officer is concerned. Mr. Das, security officer, I don't think you have a case. Security officer is responsible to look into, the entire safety of the premises.
My lord.
Here,
that is his job. Suppose some area is restricted area. It is his responsibility to not to allow people there. If any worker goes there and met with an accident, then he is responsible.
That was
so his complicity will be decided in which area it has happened and how it has happened all. So the security officer, you forget. I am only concentrating on the accounts officer and marketing officer. You file an affidavit.
Yes.
Yes. You file. Mrs. Marana, let us also for the state submits that the funding the investigation in case is still going on. Insofar as the petition, accounts officer is first one, huh?
Yes, my lordship.
Head finance, my lord, first one.
Who is the security officer?
Is second item, my lord.
Okay, second. Biswanath Bari Gora Sardio, leader Anil Kumar Taniwara, and the first the Anil Kumar Vara, the petitioner is working as accounts officer, chief accounts officer. Therefore, this complexity in the case needs investigation regarding this complexity is going on, and to that effect, second term adjourn कर दियो, third term लिख दो, marketing officer. Yes. Yes.
76.
Your Lordship, kindly see the order dated 27/1/2025 and there are Lords 5/3/2025, where this Honorable Court has been pleased to direct the Lord State Council to file and status report of the DCP Bhubaneswar.
Yes.
Not let him file an affidavit.
Yes, my lordship, I will file it today. I received this.
Survey copy or
Okay, my
file an
lord.
affidavit.
Are you filing?
I will file it, my lordship.
Or file it.
Today I'm
For the state seeks a week's time to file the affidavit.
Yes.
Pursuant to the order dated 5/3/2025. Let her do so within a week. Release the matter on 25th. 25th?
Yes.
Okay. File affidavit. Yes.
Interim order, my lord.
Interim order.
Grateful.
Yes.
My lord, one document, my lord, in the appeal filed by the builder OP2 has also been dismissed. May I?
Okay, Mr. Hon'Ble, you file it, bring it on record.
Yeah, I will.
Mr. Hon'Ble, for the petitioner seeks to place on record certain document which what is that document?
My lord, that ORAT appeal, my lord, 192/2024.
Certain document. Document, and let him file the same. Advance copy of the same be supplied to both the counsel for the opposite party number 1 and 2. Yes.
My friend is.
And you take care of that document which you.
I am serving in court. I am serving London State Council in court.
Take care of that also while filing the plan. Yes.
Certificate copy na
net download.
Download copy.
My friend also.
I am waiting for the certificate copy. I will bring it also to the record through my counter. I am waiting for that. I could not able to get.
You don't use it.
Right.
Yes.
My friend also appears there. There is no dispute that the order has not been.
Okay. What happened there?
Service has to be provided and by the builder.
The order has been passed contrary to your lordship's.
Kindly.
I am not.
Your lordship suggesting that I will leave the service provided to the and the Orient now saying I have to do the.
If you stick to that, then court will say.
Again.
You stick to that. Court is asking. I want to hand it over. Hand it over.
Yes, sir, Lord.
You get out of this mess.
Yes, sir.
If you are not, you get out of this mess. You don't want.
I am saying that I am not a developer there, but Orient now saying I am the developer. I have to perform my duty to maintain that area.
Since the patronage adjourned one
This is a big problem. I tell you, this is a big problem in.
patronage adjourned one line, paragraph 8 and 12 for a moment. One line.
देखिए कौन होगा अर्जुन अलग पर
When the matter is discussed, I am bringing to court. So why you are annoyed?
What do you want?
Paragraph 12, let's kindly see.
12, huh?
Yes. Paragraph 8 is the observation. Paragraph 12 is the order purpose of the appellate. And that is also my sole grievance.
Oh, you see brochure, transaction agreement, everything you are here. So that you are a builder.
Yes.
You are a builder. Then you have to provide it.
But the sanctioning authority given the authorization for plotting only. That is there also.
Grateful. I will bring it.
You have constructed, we plotted, constructed through someone, and now want to keep a control of the internal management.
I should not, because the matter is adjourned and other brothers are waiting.
Yes,
I will satisfy you, Lord.
Yes, yes, no problem. Item 80.
May it please your lordship.
Yes.
My lord, there was an agitation of 10,000 to 11,000 people against Agniveer scheme by the aspirants for recruitment. Yes, I am there.
Same.
My lord, I have given a copy. The entire charge sheet I have given. They were not named in the FIR. Out of the 10,000 to 11,000 agitators, the petitioners have been engaged.
Yes, Mr. Mandi.
And the question is, my lord, one.
The job aspirant, but the manner of crime.
They wanted to fight for the country.
They have not.
You don't give opportunity, they fight for the country.
They have not been anywhere. Except the, my lord.
1 minute. Yes, 1 minute, let him cover.
The 161 statements I have given, now nobody has named the present petitioners. Nor they were named in the FIR. Only question is they were agitating for that against that Agniveer scheme. And out of the 10,000 to 11,000 agitators, these petitioners have been given. And they are now, they have already been selected for other jobs. They are not getting because of this case.
Yes.
Those who are agitated in the spot of this spot. In the present, I have kind of taken the 1 to 77725 Mahadev Bear and other matter.
No more 1, 2, 3, 4 target.
I am not within that matter kind of taken up. 1 to
1277.
What is the damage caused by them?
There is before CPG Act and also there and
Where in the
100 of the Urban Police Act was also penalty for them.
No. Section 3 of Prevention of Damage to the Public Property Act you have invoked. What is the damage made?
They've thrown the latest stone the office of the army recruiting officer also. Latest stones and that is there. And damage also, but damage basically damage also that part I am not verified. Not verified also.
Oh.
Damage part damage by the latest stone used by the officers as currents. That part that is verified. I have not seen it, but
Anybody has received any injury? Because you have not invoked any serious provisions.
My lord.
Nothing.
General
23.
education.
Who has received injury? What is the nature of injury? Let us see.
That but I will also give specific environment.
Leave these people to take a policy decision. Leave these people. These people are. See, you have floated a scheme. Whatever, but now government of India is you. Therefore, I'm saying. You do it now. Because of your scheme, they were fighting.
Double engine scheme.
Now you take a call, leave them, young people, they were trying.
Every sympathy towards the petitioner talking that they are the job seekers.
But in this ground of sympathy, I can't pass unless you say or on merit I have to deal with
this
it.
part is concerned to verify.
Entire charge sheet and copy of entire charge sheet I have given.
Is there, you just go through and get instruction from the right.
There is nothing.
Insofar as these cases are concerned, you have to, drop them. Drop them because they are young people, their job perspective is also, marked because of this. Yes, all of them are 23, 20, 20.
My lord, all are young men.
Why are you after them?
And who are only agitating.
Seek instruction and come. I will put it on 22nd.
Yes, sir.
And write a letter to the right person.
Can it be earlier?
Because
once the problem is once the authorities say that your jobs are filled up or something like that, then this will be prejudiced.
Which job?
Because they have been selected for jobs.
Where have you said that?
I've given that.
Where have you said that they are selected somewhere?
Your lordship, may kindly turn to page 4 of my petition, para 11.
11.
My lord.
FIR was registered in 2022, you came now.
No, now because I've given the details where I have been given appointment, but have not been given appointment, though we have been selected. This selection list I have given. We are not only because of the pendency of this case. We came to know of this only because we went for appointment and they said that this case is pending against you.
Okay, sorted. What will be, he'll seek instruction, the holidays are there.
No, I have given the entire charge sheet.
No, he has to seek instruction, he can't concede. Then on merit, then everything has to be changed. On merit, then everything has to be changed.
And nowhere they have been named.
Merit, then each petitioner's complexity has to be seen from the record. It will take a lot of time. Better that he should get the instruction. Let it be on 22nd. Let it be.
Earlier,
see, without fail, you have to get instruction. Yes. Write a letter and get instruction.
Interim order.
Interim order.
No, interim order has to be given. Last time it was not given.
Stay the proceeding. Stay the trial. I'm staying the trial court proceeding.
It is reasonable.
Stay the trial court. Yes. Yes.
81.
देखिए तो बुक रखी stay court.
1277 I am appearing.
Yes. Of the trial court proceeding stay. Yes.
May it please my lordship.
81.
May it please my lordship and lords. The lords, this matter has been argued at length. Just because he gave another written argument, I'm responding to the same. My lordship sees, to recapitulate my lordship's memory, the court below, the Vigilance, Special Judge Vigilance Keunjhar, in 1 of 2019, stated at the time of filing a petition under 227 for discharge, he wrote, the accused may have a good case to agitate, but this is not the stage. Against that, I have come up in revision on 2 grounds. One ground was the court had the existing jurisdiction, but did not exercise that jurisdiction. Now, keeping that in view, I have come up before my lordship saying where the court had the jurisdiction and did not exercise the jurisdiction. Then when my lordship brought the matter, then my lordship would see 227 categorically states, if upon consideration of the records of the case, 1, and the document submitted therewith, 2, after hearing the submission of the accused and the prosecution on this behalf, 3, the judge considers that there is not sufficient ground for proceeding against the accused, 4, he shall discharge the accused and record his reason for doing so. Not having done so, I have come up in revision. Now the question that arises in revision, I brought it to my lordship's notice by virtue of the Supreme Court judgment that if the disproportionate asset is 10 and less, then the man has to be discharged, totally has to be discharged from the case. Based on that, my lords, all the records that were placed by the prosecution, based on that, I came to the conclusion, initially the charge sheet was at 138%. When they filed the charge, it was 38%. And when I brought it to my lordship's notice, it was minus 6.77. With that, after it was concluded, my lordship would see the provision of revision. I have submitted 2 judgments in my written note of argument saying in a revisional matter, my lordship sees page 3 of my note, which I have subsequently given, which is very, very relevant. Therefore, page 3.
Yes.
Of where my lordship sees the court has in a catena of decisions provided that the nomenclature of a petition is immaterial, and for doing substantive justice, the High Court can always convert a petition under 482 of a criminal procedure code to a revision under 397 procedure and vice versa.
Yes.
Then subsequently, that in view of the matter, it is worthwhile to, as decided in 1977, 4 SCC 511, judicial approach would have been to convert a petition under 482 to a criminal so my lord.
482 jurisdiction is wide enough. Even
So my lord.
482 jurisdiction is wide enough. Even I can exercise even without
And also in revision to do
But
inherent.
how will you meet with the argument of Mr. Das that this court, while exercising 482, can't convert the court to an accounting class and calculate things?
No, to that
the
my
calculation
answer
which you have given is purely an accounting business.
I've given it here on the first page. My lordship sees. I've given the powers of revision on the left hand side. In case of any proceeding, A, B, the records has been called or otherwise comes to its knowledge. C, he may in his discretion exercise. 4, any of the powers conferred on the Court of Appeal will be disposed of in the manner provided, made to be prejudicial to the accused as contemplated under 401 subclause 2, unless any opportunity has been heard either personally or through pleader in the interest of justice to do so. So therefore, in the interest of justice, my lordship can do and undo anything for dispensation of justice is my only answer.
Yes.
That is all, and my lordship would close this matter.
Yes, Mr. Das.
Humble submission.
Lords, may I pledge your lordship, lords? Lord, before I place 2 pages notes, I filed, my lords, and the lordship both lords.
And before he proceeds, my lordship would see his paragraph 3, which is very, very relevant, which he has quoted a judgment, paragraph 3.
I have seen that.
Where he said, there my lordship would see where any right of the accused to produce. We have never produced anything. We have never produced a scrap of paper.
Yeah.
That is how I am distinguishing it. So these judgments are not at all relevant at all. I would very fairly and humbly submit, this is neither fish nor flesh. But I would not further say anything more and leave it to my lordship to say that it is of no substance. Any of the judgments which he has cited is of no substance. Why I say so? Because the powers bestowed upon my lordship cannot be abrogated under any stretch of imagination for dispensation of justice. It is very unfortunate I cannot be before my lordship because I am very sick, my lords, with very high fever. And that is, I feel unfortunate.
Then I can put it some other day if you want.
No, my lords. I want to conclude it, my lords. That is why I've sat waiting for my lordship to hear me as the last case for the day.
Okay, let us
Lords, if a lordship permits me, lords, I'll confide my submission within, lords, 3 points, lords. Before, lords, I place that relevant portion from the note of submission. Lords, you can see that page 61 of lordship brief, lords. The revision petition 61, lords. At page 61, lords, to indicate to lordship the first line, lords, that application was filed under section 227 CRPC. That was being rejected, lords. They have proposed this on the court. Lords, but turn to the second page, 64, lords. Why the interim was passed by this honorable court, lords? Because my learned senior indicated brought court's notice to page 64. That one line was the turning point. Lords, you can turn to page 64, the second line. The accused may have a good case to hesitate, but this is not the stage where the same should be analyzed. It's a good case, Lord, for the trial. Lords, but that was a turning, what, Sunish? My lords, and for that,
You have already.
Lords, my lord, that was placed and ultimately intimate was passed, turning the entire process, my lords. Now, my lords, the essence, the main thrust of my learned senior submission is, my lords, that the calculation put forth by the prosecution, my lord, by way of filing a charge sheet before the London trial court at the time of consideration of the petition's application, my lords. My lord, the calculation is not correct, my lords. And my lords, for that reason, my lord, though the accused is always debarred, is prohibited in producing any documents, my lord, whatsoever, my lords, which is not part of the material produced by the prosecution at the time of consideration of this application, my lords. Now he has introduced many documents, including a particular note of submission and all these submission, my lords, which is not part of the charge sheet, my lords, which is not part of the materials produced by the prosecution during the London trial. That is my humble submission.
Note of submission is not a document.
My lord, this submission, that's the, my lord.
What are the documents?
My lords, 1 minute, but your lords, you can permit me 1 minute, 1 minute small. Now, Sunish, my lord, the judgment of the which is governing the field, my lord, the landmark judgment is emanated from Odisha. The state of Odisha, Devendra Party, 2005, 1 SSC 568, my lord. It says two things. The accused has no right to produce any documents, one, and secondly, the accused has the right to put forth the submission, but the submission should be in consonance with the materials produced by the prosecution, not contrary.
That's what I'm asking. Which are the documents he's relying upon now?
My lord, he relies a particular calculation sheet, my lords.
Calculation sheet is not a document.
Yes, a submission. The submission which doesn't, which is not part of the material.
Whether the calculation he's putting today is based on some other document.
Yes, my lord. That is his calculation.
1 minute. Please hold on.
My lord, the submission.
Please hold on.
Mislead you, Lordship. For that reason, I'm just
Be sure that nobody can mislead me. Don't worry.
My lord, the submission of the accused is always confined to the material produced by the prosecution. This is the settled legal position, my lords. I don't take any contrary.
No, what?
And the calculation.
So that's what he's trying to say is the calculation on the charge sheet which you have filed. The calculation is wrongly done. If it is really calculated, the DA would come down less than 10%, that is 6 some percent.
That is his submission.
So the calculation, he doesn't say that you calculate in the on the basis of some other document. He says that the document which you are relying upon, on that basis you please calculate it. You are wrongly calculated. Mathematical calculation is wrong.
No.
And you argued that day. You argued that day, rightly so. You say that the 482 codes are not the chartered accountant, that you can keep on calculating things. Calculating wrong or right, that is a matter of trial.
That is one.
That's
on that score, the second.
And there is a judgment you have ready.
Okay. That is one. I'll place that one. The second submission on that score is, lords, in the decision in the state of Tamil Nadu and N. Suresh Rajan, this court held that the Honorable Supreme Court held at the stage of consideration of application for discharge, the court has to proceed with the assumption that the material brought on record by the prosecution are true. Like or not, whether you like or not, are to be accepted true and evaluate the materials to find out whether the facts taken in their face value disclose existence of ingredients constituting the offense.
Suppose what will happen if in the charge sheet you have written 5 plus 5 is 20 if you have written. And in place of 10, if you have written 20, can the court shut the eyes at this stage saying that no, it should be 20? You believe it to be 20 and proceed.
My lord, may I submit one thing? The third submission that score is, my lords. Then this particular plea, that calculation, all that, this is a plea to be ascertained, my lord, has to prove, my lords. It cannot be in a revisional jurisdiction, my lord. This amounts to assessing the
I'm not reassessing. I'm not going to do it.
And
the calculation which you have made, mathematical calculation, arithmetical calculation, is correct or not?
That is correct. That is my statements, more. I stand by it, Lord. There is absolutely no error with regard to calculator. This is
That's
this
the
is
answer.
elementary, my Lord.
That's the answer.
What there should be? Is there any kind of addition? He says, no, these are the things left out. These are the things added. My Lord, then
These things can't.
then his desired percentage come down to 7%, Lords. My Lord, my Lord, he is the entire endeavor of my learned senior is, my Lord. Look, these are the materials you left out. These are matters to be added. If you accept that one, then my percentage comes down to below 10%.
Then you may be correct.
My Lord, thereafter, my Lords, what is the scope of this Honorable Courts, my Lord, with regard to the finding out the this order cannot be faulted with, because another reason, my Lords, the Supreme Courts in a very categorically held that, my Lord, the challenge to order should be entertained in rarest to rare cases and not to reappreciate the matters. My learned friend entire endeavor is this Honorable Court on the revision jurisdiction to reappreciate the matter. That is forbidden. And my lords, with regard to the second, the last submission, my lords, with regard to calculation, my lord, we expecting revisional court, this Honorable Courts, my lord, and my lord, what it says, my lord, that the Honorable Supreme Court held, the Honorable High Court ought not to have done the role of a chartered accountants, expecting this Honorable Court to calculate, subtract, multiply, divide. These things are prohibited, lords. My humble submission, my lord, the input orders passed by this by the learned High Court, Lord, neither can be faulted with, neither suffer from any purpose, my lords. The materials produced by the prosecutions taken care of, lords, and all the submission of my learned friend can be categorized as defensively, which requires to be tested on the basis of these untested documents, my lord, are required to be proved in the trial, my lords. And there are materials to proceed, my lord. This is not a groundless case, my lords.
Thank you.
My lord, in response, I would only say one line, my lord.
Yes.
There is existence of jurisdiction and there is exercise of jurisdiction. When the court had the existence of jurisdiction, that is the special court.
I got it. I got the point. I got the point.
And
my last line, my lords, my notice submission is flagged D.
Lords, in 2000, January 12, 2024, this question can be raised at a revisional stage, at any stage, because it talks of three jurisdictions. One is territorial, one is pecuniary, and the third one is subject matter of the jurisdiction. So when there are three types of jurisdiction, the subject matter of jurisdiction can be taken at any stage.
Okay.
Yes. I'm deeply obliged for my lordship.
Oh, this is the next one is 82. 82 here. Yes. Yes.
From 82, that vigilance matter.
I take leave
Secretary of the Cooperative Bank Regiment to the accused.
I will hear you tomorrow.
Yes, my lord, I know.
But I want to hear for 10-15 minutes that ladies matter. She is coming and mentioning every day. She's in person, she's doing it. I can't ignore that.
Can it be tomorrow 2 p.m.?
Not 2 p.m., but I'll hear you. Let it be there.
All right. If lordship is inconvenient. 3:30 maybe fixed it will be.
3:30 Budhwar, 3:30.
I will take hard to
How we'll do it?
Oh, yes, we complete. Your hard at length.
I've done it, but that lady is every day mentioning.
Yes, my lord.
Somebody is coming in person, you can't pick up.
If your lordship permits, my lord, Mr. Party is there, my lord. My lords, out of the way. My lords, in that agreement matters, my lords. There's a provision on the CRPC for withdrawal of prosecution.
Why don't you do that?
Withdrawal of prosecution, that provision is there.
I just spoken to my learned friend. That is the government prerogative to have a special order for this.
Because I was in law department.
And he has not mistaken that you are the.
No, he's correct.
Rightly he asked me.
He has rightly said.
You are the government, therefore he came.
It's a part of this matter.
So please try and do it. Young people, why to spoil their life?
Neither they have any cause any injuries nor
to me, except the Monroe Commission case, this government take a very firm decision. Thereafter, don't think that anybody is implying with his mind and do it. It can be done within 5 minutes.
You please speak to.
Yes.
He can use good
Advocate General and.
He can use
I also put a word if possible, then Mercy also make a
prosecution against the young people.
There is a provision does here.
Naturally. The prosecutor has to move application.
Yes,
Yes.
And
You have to do more
it is to rotate to the law department.
in the law department, yes.
Why do you do that?
Then the law department will look at it.
Why do you do that? Say many youngsters,
Now, future
their life
will
will be ruined unnecessarily.
Yes, sir.
Try to do it.
Obling.
Yes.
Then 3:30 and on 30th.
Yes.
Obling.
Weekly list items.
Sir, I remember that I'll take it up your matter, but let me spend 10-15 minutes for that. He's coming in person every day. Weekly, I'll take it up. Let it be there. 3:30 you come. Today it got delayed, but
Tomorrow, my lord, maybe taken, please.
tomorrow also may be possible. Which one? Which one?
102 of the weekdays. Each in chapter.
They need
100.
102. 100.
100 also, man.
Note down. What?
100 and 102. Both.
I know, weekly list.
Weekly 100 and 100.
I know, but you please note down. Let us hear. Let us hear for 5 minutes.
Madam, actually, my lord, in a short, I will tell, she was working as a Thursday lab. Money was received, actually, money was never.
Madam, you please take your seat. You have a lawyer, he'll argue. Please take your seat, don't worry.
My lord, that actually the money for 4,000 was never recovered from her. It was recovered from her office, which was accessible to all the persons at that time. She was stopped 200 meters away from the office. Her bag was searched and no money was recovered. And actually the dispute is between two persons. She was working as the Tahsildar Louis Singer. She allowed water to somebody from a Bandamunda water tank. So with a person, they have specifically said that she denied money to be received on the day before yesterday. So next day they filed the case. And money was never recovered, and it was no demand was seen, and actually the informant has died in the meanwhile. And the witness who was said, he is saying that one door skin was there. At the same time, he is saying that there was an indication that. So you allow us to, in details, take up the matter. I'll tell you.
You have prepared a written note?
Yes, I have prepared.
So give me.
Tomorrow I will submit that. So I have prepared. Tomorrow I'll give you in details. Sir.
Tell your client not to come unnecessary. Why? She's every day she's coming and mentioning. Since you are there, advise your client not to come and mention. And I'll hear it. No, correct. Yes.
This item number 1, with the lordship permission, we withdrew and it was disposed of. We have filed as another CLBC minutes. The diary number has been done.
Will you be listed? Why do you want? Will you be listed?
Yes, ma'am.
Listed.
Deeply.
Next week, we will be
Tomorrow, deeply.